He's coming on through like a phone or a laptop.
Just put the, oh, so your your microphone is on.
I think, oh yeah.
Yeah, cool, good. Shows up.
To order. We'll get started by the reading of the preamble. Madam Secretary.
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this Monday, November 10th, 2025. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We've also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you for that, Madam Secretary. Can we call the roll, please?
Ms. Holzer?
Present.
Ms. Roca? Present. Mr. Madison? I think I saw his name on here. Mr. Madison?
Present.
And Ms. Faith? I believe Ms. Faith will be absent this morning. She did say that she had a private matter this morning, and may not be able to join. And Ms. Wilson.
Present.
Madam Chair, we have a quorum with 4 members. With 4 members, we should let the opponents know that they run the risk of a tied vote in this case. If there is a tied vote, the variance is denied. At this time, the appellants may request a postponement to a future date, which would be, as far as our records are concerned, I believe it's December 15th. If they would like to postpone to that date, they may request to do so at that time. The appellants may. Thank you.
Okay. Any appellant wishing to postpone their matter, given we only have 4 members today? I do see a hand raised online. Nico, do you want to postpone your case?
Yes, please. I would like to wait until there is 5 or more people present to vote on this.
Okay, we will do that. What is the address of your property?
5011 Clark Avenue, Cleveland, Ohio, 44102.
Okay, got it. So this is calendar number 25-123. I am assuming that you are from Gill House LLC. Is that correct?
No,
Madam Chair.
but we have the letter stating that we can speak on all matters within the violation.
Okay, that is understood. Chief Leonard, did I hear you chiming in there?
Does Mr. Madison, is he going to be joining us today or is at all, or?
Yeah, he's online.
And you said the other member will not be here at all, so there'll only be 4 members for the entire of the day?
That is correct.
Okay, I just wanted to see, because if somebody else was joining later, see if we could just table it to the end of the meeting, since I believe there's several building and housing officials here for this case.
Oh, I see.
Madam Chair,
Okay.
we do have a text message from Ms. Faith.
Okay.
stating She'll be joining us.
Oh, great. Okay. So then we would not need to postpone it. We do have 5 board members who will be present. So we'll recall this case later on in the agenda, hopefully once she's here. All right. So we'll go ahead and get started by calling the first case. That is calendar number 25-171. This is at 6725 Dennison Avenue. Do we have the appellate from Braff LLC present?
Good morning, yes, present.
Oh, perfect. All right. We'll go ahead and read the case in. I'll turn it over to you, Ms. Holzer. Do we have any postponements and withdrawals?
No, we do not. Thank you.
Okay. All right, Ms. Holzer, you want to read in the case?
Sure. I'll wait for the PowerPoint to catch up.
Okay. Yes, please come forward.
Okay. Our first case is calendar number 25-171. This is a violation notice regarding 6725 Dennison Avenue. RAV LLC owner appeals under the authority of section 76-6 of the Charter of the City of Cleveland and section 329.02D of the Cleveland Codified Ordinances from notice of violation number V250254429 issued on July 31st, 2025 by the Department of Building and Housing for failure to comply with section 327.02C of the Cleveland Codified Ordinances, which states that there shall be no change, substitution, or extension in the use of any building or premises until the required use permit and certificate of occupancy have been issued by the Division of Building and Housing. Per section 347.21, any establishment using 20% or more of floor, shelf, and/or display areas individually or in aggregate for the sale of smoke shop products is defined as a smoke shop and requires an application and approval from the Department of Building and Housing. And this was filed on August 20th, 2025. Do you want to do the oath?
Sure.
Okay. And with that, I will hand over to Ms. Roca for the oath.
Thank you, Ms. Holzer. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the truth and nothing but the truth? Please raise your hand, state your name, spell your name, and give your address. And also say I do.
Yes, yes. Excuse me. Before we start, can you hit the red square on your microphone? And then that'll, when your light turns green, means we can pick you up on audio.
Okay. I'm sorry, what was I supposed to say again?
You'll want to raise your hand, state I do, state your name, spell your name, and give your address.
Okay. Anastasia Smith, ANASTASSIA Smith, SMITH. Address 601 Lakeside.
Yep, that's right. And do you swear?
I do.
Thank you.
And my name is Michael A. Glazer, GLAZR. I'm an assistant law director of the city of Cleveland, and I will not be testifying, but I am here to provide testimony to question the witnesses. Thank you.
Thank you. Anyone else who wishes to speak in this case, online or in the room? I see someone's hand up, but I think it's a old hand. Oh, Ms. Faith has joined us. I'm not seeing anyone else. Madam Chair, back to you.
All right, thank you for that. Let's go to legal, please.
Madam Chair, members of the board. Appellant is appealing a decision of the Cleveland Department of Building and Housing. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, thank you for that. And who do we have from RAV LLC?
First name is Rashid, last name is Abu Ali, RASHED ABOUALI.
Oh, we didn't swear you in.
Okay.
Do you swear or affirm the testimony you're about to give today is the truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and give your address.
Rashid Abu Ali, RASHED ABOUALI. I do.
And your address, please.
6729 Denison Avenue, Cleveland, Ohio 44102.
Thank you.
All right, now that you're sworn in, do you want to go ahead and tell us about your appeal, please? Oh. We can't hear you if you're speaking. Are you there?
Yes, I'm sorry, I'm here. It just muted when I opened the camera.
Oh, that's okay. Go right ahead.
Okay, I stated, did you hear my name?
Yes, we did hear your name.
Okay.
All right, we're just waiting for you to go ahead and tell us about your appeal.
Okay, my appeal was we were under the intention that we were under 20%, and we are no longer continuing a smoke shop or anything to do with any tobacco products. I've been here for about 15 years, and this has always been a clothing store, and that's the way we're intending to keep it.
Okay, does that conclude your comments?
Yes, for now, yes.
Okay, thank you for that. I'll turn it over to you, Attorney Glazer.
Thank you. I think I'd like to hear from Inspector Smith, who issued the violation notice, and just whether she's been back to the property and whether they are in fact under the 20% or eliminated smoke shop products.
Okay.
So, Inspector Smith, have you revisited the property since the issuance of the violation?
Yes. I believe it was last week, I believe November 6th. And we went back before then, talked to the owner, and the owner did explain that they were going to turn the store back into a clothing store. They had already started taking things down. And then when we went back on the 6th, circa that day, we did take pictures, and they have since removed all smoke shop items. Sorry. Yeah, continue. Okay. Say that. Yeah. Okay. And I actually noticed when he opened the camera, you could see that I saw the store. I could say, hey, I know that store. And you could see that he's putting the shoes and stuff back on the rack. So yes, they have, as he stated, they are turning it back into the clothing store.
Okay, thank you for that. Anything additional, Attorney Glazer?
No, I think Inspector Smith's testimony is that they converted away from a smoke shop, and I would just defer to the judgment of the board on what to do with the violation.
Okay, any questions from the board?
Madam Chair, could we put up the photograph of the front of the building, please?
Sure can.
And is this the storefront that was called Denim?
Is that the store, Inspector?
No, it's the store next to it, the one that has the sign that says cookies.
All right. All right, I just wanted clarification on that. That's all I had.
All right, thank you, Ms. Faith. Any questions from other board members? All right, I'll entertain a motion.
Madam Chair, given that the store owner has stated that he is converting the store back into a retail clothing store, and the inspector has stated that he has witnessed the transition back into a clothing store, I move approval of calendar number 25-171. Just trying to make sure that approval is the right thing, since this is a violation notice.
Right.
Ruling in favor of the business owner, since they no longer are operating as a smoke shop.
Okay, understood. We have a motion. Is there a second?
I second that we return the violation notice.
Okay, can we call the vote, please?
Mr. Madison?
Aye. Yes.
Ms. Ms. Roca?
Yes.
Ms. Holzer?
Yes.
Ms. Faith?
Yes.
Ms. Wilson?
Yes.
Calendar 25-175 is approved. The violation notice has been overturned. This decision will be ratified next Monday, and we will send the appellant a letter.
All right, that concludes this matter. Thank you all for being here. We're now going to call the next calendar number, which is 25-185. Do we have someone present from 3477 West 117th Street, LLC? If you are present, please come forward. All right, and while you do that, I'll go ahead and have Ms. Holzer read in the case.
Our next case is calendar number 25-185. This is at 3477 West 117th Street. 3477 West 117th LLC owner proposes to include a smoke shop in an existing retail store in a local retail business zoning district. The owner appeals fully from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. And with that, I will hand it over to Ms. Roca for the oath.
Thank you, Ms. Holzer. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and give your address.
I do. My name is Fadi Zayed, Fadizayed. My address is 3477 West 117th Street.
Can you spell your name again? I'm sorry.
Yeah, Fadi, and then Fadi, and last name Zayed.
Okay, my name is Michael Glazer. I'm an assistant law director for the city of Cleveland, and I will be not be testifying, but here to provide legal argument and inquire of the witnesses.
Thank you. Is there anyone on the call who wishes to speak on this case? I see your hands up. Mr. Lowell.
Good morning, Nate Lowell with Cleveland City Planning, 601 Lakeside Avenue. I do.
Thank you. And anyone else on the call? Anyone else in the room? I'm not seeing anyone else. Back to you, Madam Chair.
All right, thank you for that, Ms. Roca. Let's go ahead with history of the property, please.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 2006, it was changed to local retail business. In our Records Administration Office, we found that in 1922, a permit was issued to erect a 2-story stores and dwelling building and a garage. In the more recent history in our cell system, we see, well, relatively new, 1999. A certificate of disclosure was issued stating that the use of the property is as 2 dwelling units and 2 stores. There is rental registration issued to the property beginning in 2017 and 2016 as well, I'm sorry, in 2022 and in 2023. A lead safe certificate was issued to the property as well in 2023. In April of 2024, a violation notice was issued to condemn the garage. In May of 2024, the garage was demolished on the property. Rental registration was issued in December of last year. And then June of this year, a violation notice was issued regarding unauthorized use as a smoke shop. And there are no variances on file for this address. Thank you.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is requesting area variances from the minimum distance and permit application requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
All right, thank you for that. I will now go to the appellant. Do you want to tell us about your variance request?
Yeah. We purchased the business back in 2021. It was a pre-existing smoke shop. We just made it a little bit look nicer face, building and everything. And it was always a pre-existing smoke shop. We just added a little bit more to it. And we're just starting to appeal that it was always a smoke shop. We were one of the first ones on the street. And yeah, that's it, honestly.
Okay, and when you opened your business in 2021, did you get a certificate of occupancy to operate as a smoke shop?
The occupancy, no, I've gotten all the other things that they asked. That was not one of the things that was required. I was still new to it, so I didn't know everything. I had like other people help me, siblings, brothers, cousins and stuff that had more experience. It was my first time in business, so I didn't know. So I got everything that was required, from cigarette license, vendor license, and all the other license needed for a smoke shop. But back then it wasn't needed, and not that I knew of.
Okay.
Yeah.
All right, thank you for that. Do you have questions of this appellant?
Yes, thank you. So did you or someone with the business apply for the license for the smoke shop when the ordinance went into effect in April of 2025?
Yes, we did.
Okay, why was it denied? Was it denied because it was too close to another smoke shop or too close to a school or church?
No, we're not too close to a school, church, or park. It was because we were too close to another smoke shop, but we were existing before that smoke shop.
Okay. And do you sell any products aside from the smoke shop products?
Yes, we have a little like jewelry store in there. Like it's like a little pop-up shop. And then we have a little bit of clothing and keychains, and it's like a mix of varieties of convenience store stuff that would have as well. So yeah.
Okay. Well, that's all the questions I have right now. If I could reserve some comments perhaps at the end.
Sure.
Thank you.
Mr. Lowe, I'll give you an opportunity to chime in. Oh, wait, I can see Chief Leonard, your hand is raised. Go right ahead, please.
Yes, I just want to let you all know that he did not apply for a occupancy permit until after the violation notice was issued. And the letter of nonconformance does state that he is within 500 feet of one of the protected parcels, as well as within the distance buffer of another smoke shop.
Okay, thank you for that, Chief. Mr. Lowe, you have the floor.
Thank you, Chair. Good morning. Again, Nate Law with Cleveland City Planning. I believe we have a few slides just to advance and kind of go through city planning's perspective on this. As you all know, We passed new legislation in April of this year to prohibit smoke shops in certain areas and provide more restrictive guidelines. As you can see by the map here, the star showing the location of the smoke shop, there are a number of legally existing smoke shops that have certificates of occupancy shown by the green dot. Additionally, the red outlined areas are the 2-mile buffers. So you can see the saturation on this area of already legally existing smoke shops. And then here's the 500-foot buffer that we were talking about. It is within 500 feet of a park, Halloran Park, just down the street here. And so our position is that we don't believe that this business is unique in any way, or the parcel or the zoning restricts it from other legally established uses. And therefore, the variance should be denied because there's no hardship. It sounds like they can sell other products like jewelry and clothing and reduce the number of smoke shop items to under 20%. Thank you.
All right, thank you for that. Chief, I can see that your hand is raised. Do you have additional comment, or is that an old hand? Looks like an old hand. Okay. Any questions from the board?
Madam Chair, I have one question for the appellant. Would you be able to reduce your smoke shop products to under 20%?
I believe we could. We've been taking out a lot of stuff that we thought was more harmful, or stuff that didn't wasn't a good look for our store. So we've reduced that a lot. I think we can get close to it. I mean, it's a smoke shop, so a lot of this stuff does have a little bit to do with like tobacco or smoke shops. So, I mean, it'd be kind of tough just because that's mostly what we sell, but it's not everything we sell. So,
Thank you.
All right. Any other questions from the board?
Yes, Madam Chair. So as Mr. Lull and Ms. Leonard noted, this business operating as a smoke shop is within 500 feet of Halloran Park. It is also within the 2-mile buffer of another smoke shop, which is probably a half a mile north on 117th. It is also, which wasn't noted, about a half a block from a child care center. The other issue with this particular business is that the front setback has been completely paved from the tree lawn all the way to the business with asphalt, and parking lines have been striped. So they're using the front yard setback as a parking lot. In addition, they're using the side yard, which has also been asphalted, which is next to the building, as a parking space. I'm looking at a historical photograph from 1922, which shows a vehicle parked alongside the building, which sometimes infringes on the public sidewalk and is also within 10 feet of the opening of the building, and is also quite common. There is a posted no parking sign on the utility pole to the side of the building, and very often there are patrons parking beyond that no parking sign into the right of way for the intersection of the side street and St. Mark. So there are numerous issues with this particular business above and beyond them operating as a smoke shop. And particularly of issue is the parking in the front yard setback. And on occasion, I have personally witnessed cars using the handicap walkway ramp as an exit out of the parking lot into the intersection. So there are numerous reasons besides the operation of the business as a smoke shop being within boundaries of a daycare, a park, and other smoke shops.
All right, thank you, Ms. Faith. Any questions from other board members?
I think the final question I have for the appellant is to testify to the board what the difficulty is that you would face if these variances were not granted today.
I mean, difficulty to be is that was like the first store we've like my first business. I have another one. It's not a smoke shop. It's just part of a coffee store, but it's not really profitable. And that's like the business I've always relied on since 2021. Worked there for years. Never sold underage. Never did a lot of the things a lot of other smoke shops got cited for. I understand, I hear what she's saying, and there's some things that can get fixed, but to my concern, some of those things I never realized or are definitely noted. So, yeah.
Thank you.
All right, Attorney Glazer, you want to chime in?
Thank you. Thank you, Attorney Wilson. And just by way of legal argument, I think that the purpose of the ordinance is to limit smoke shops and to avoid saturation and to avoid them being too close to certain protected properties. And we have both of those things here. I think the issue of practical difficulty or unnecessary hardship due to the physical size or other characteristics of this parcel, I think that's not present here. It still could operate as any type of store and could even sell smoke shop products at under the 20% threshold. And since the store can be operated as another type of store, or a type of store with less than 20% of smoke shop products, there's not a deprivation of substantial property rights. And I think granting the variance would be contrary to the purpose of the ordinance, which is to limit smoke shops. And that's all. Thank you.
All right, thank you for that. I'll entertain a motion from the board, please.
Madam Chair, to the attorney's point about it operating as another business, this particular business, prior to it being a smoke shop, did operate as a carryout pizza business. So there is opportunity for other types of business in this location, as it was previously had another use.
All right, thank you, Ms. Faith. It sounds like you have a motion.
I motion denial of calendar number 25-185 based on all the testimony we've heard today from city planning and the attorney.
All right, we have a motion. Is there a second?
Board Member Marcus Madison, seconds.
All right, thank you, Mr. Madison. Can we call the vote, please?
Ms. Roca?
Yes.
Ms. Holzer?
Yes.
Mr. Madison?
Yes.
Ms. Faith?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-185 is denied. This decision will be ratified next Monday, and we will send the appellant a letter.
All right, that concludes this matter. We'll now call the next case, which is calendar number 25-186. Is David Sims here today or online? David Sims, owner of 10213 Etna Road. Are you present and with us today? All right,
Or
hearing
Kim
none.
Harper? You have a Kim Harper in there.
Okay, is
She on?
Kim Harper the appellant here? Oh,
There's
yes,
a
we
Kim
do see
Harper
Kim
online.
Harper online. Kim Harper, are you here for the case located at 10213 Etna Road? All right, last call, Kim Harper.
Okay, can you hear me okay?
Oh, I can hear you now.
Okay, sorry about that. I guess I was muted.
Oh, that's okay. Are you
I am
here?
I'm present for the 10213 Etna Road.
Okay, all right, very good. We'll go ahead and read in the case. I'll turn it over to you, Ms. Holder.
Our next case is calendar number 25-186. This is at 10213 Etna Road. David Sims, owner, proposes to use premises for childcare in a B12 family residential zoning district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. And with that, I will hand it over to Ms. Roca for the oath.
Ms. Holzer, I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth? Nothing but the truth. Please raise your hand, state I do, state your name and spell your name and give your address.
Yes, Kim Harper, KIMHARPER. That's at 10213 Etna Road, Cleveland, Ohio. And I will reply with I do.
Thank you. Anyone else on the call who wishes to speak in this case? Anyone in the room? I am not seeing anyone else. Back to you, Madam Chair.
All right, thank you for that. Can we have history of the property, please?
Sure, thank you. This property was originally zoned general retail in 1929. In 1950, it was changed to local retail business, and in 1972, it was changed to two-family residential. In our Records Administration Office, we found that in 1921, a permit was issued to erect a two-story stores and 3 apartment dwelling structure. And in 1922, a permit was issued to erect a garage. There's one variance on file in calendar 75 and 146, and that was in 1975. This board granted a variance to use space in the easterly storefront to establish use as a self-defense and health store. At the testimony in that record stated that that property had been used as a tavern previously. And then in the more recent history, we see that in 2003, a permit or a violation was issued for condemnation of the property. But then in 2004, there were various permits issued to the property correcting the violations. 2023 lead safe certificate was issued to the property. And I think that's all that I have that's relevant. Thank you, Madam Chair.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is requesting an area variance from the minimum distance requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
All right, thank you for that. Ms. Harper, you now have the floor. Can you tell us about your variance request?
It sounds like, from my understanding that, I guess I was denied because the property was zoned as residential, but there is the commercial, as she noted, the eastern side of the building. And that's where I'm looking to rent the space for childcare. So it is zoned as a commercial property. There are residential units upstairs as well, but I'm looking to rent the space that's available for commercial. And again, that is for childcare center.
All right, questions from the board?
Yes, Madam Chair, to the appellant, what is your relationship with Mr. David Sims?
We're friends. We've childhood friends since we were 9 years old. I won't give our age now, but
And with respect to the property, what is your relationship with him?
again, just this would be business.
So he owns the property and are you a tenant currently?
He owns the property, and I'm looking to become a tenant with the childcare center.
Okay.
Madam Chair, we do have authorization from Mr. Sims for her to act on his behalf.
Okay, perfect. Thank you for that, Madam Secretary.
Thank you. And then can you tell us more about the childcare business you like to operate? How many children, hours of operation, how many employees, et cetera?
Sure. At this time, I am looking with 6 to a possible 10 to 12 children. Again, that would be starting off with 6 children. Hours of operation will be between 7 a.m. to 5:30 p.m. Monday through Friday. And yeah, that's about it for as far as, the timing, the scheduling.
How many staff members will you have?
With staff members, as long as there are 6 children and below, that would just be myself, um, provided with the space. If I am allowed to have more than 6 children, there will be an additional staff member. So one other
And-
staff member.
Okay, thank you. And then what are the ages of the children that will be in the center?
Preschool, so that would be 2.5 to 3 to up to 5 years old. So preschool to like pre-K.
Thank you. That's all I have at this time, Madam Chair.
All right, thank you. Any other questions from the board?
Madam Chair, my only question is, the parking situation and, for herself and potential staff and, drop off and pick up for the children. This is a corner lot, so I'm interested to know where she plans to use her safety zone for the pickup and the drop off.
So there is parking located behind the building. Um, Also, there is parking along the side of the building, which would allow the parents enough time to pick up and drop off at those times. For myself, as far as parking, again, there is available parking in the back of the building. Um, so that would allow, my car would be off in the parking area, as well as the parents have the option to, because it can be zoned off where the parents can park also, because there are 2 entrances, sort of in the back of the building, and be able to escort the kids into the building.
Great, thank you.
All right, any other questions from the board?
Madam Chair, just would love to hear the city's presentation on the saturation.
Yes, was going to get there next. Just want to make sure no other board members have questions. All right, we'll turn it over to you, Mr. Bay.
Good morning. My name is Xavier Bay, representing City Planning. The proposal here is for a 6 to 12 child daycare. So the main reason we're seeing this is because it's a 2-family residential zoning district and abutting to more 2-family residential zoning districts. And so we are supportive of this proposal. It's on a corner lot and it's a very low intensity business. And the applicant is doing well to continue to maintain the property. So it's great to see that this has come down out of condemnation and is to be continuously used. Thank you.
All right, thank you for that, Mr. Bay. I'll entertain a motion, please.
Madam Chair, given the testimony we've heard today, and this is a mixed-use building, she intends to use the eastern portion of it for her childcare. We've discussed the drop-off situation. It's a corner lot, so it seems to be safe. So given all that, I move approval of calendar number 25-186.
All right, thank you, Ms. Faith. Do we have a second?
Board Member Holzer, a second.
All right, thank you, Ms. Holzer. Can we call the vote?
Ms. Roca?
Yes.
Mr. Madison?
Yes.
Ms. Holzer?
Yes.
Ms. Faith?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-186 is granted. This will be ratified next Monday. We will send the appellant a letter, but she can contact us next Wednesday for further instructions.
Awesome. Okay.
All right, good luck with your project. That concludes that particular matter. We're going to move now to calendar
you.
number 25-187. Do we have Michael Fiala present? All right, go ahead and come forward. And while you do that, I'll have Ms. Holzer read in the case.
The next case is calendar number 25-187. This is an appeal from the decision of Cleveland Landmarks Commission by Michael Fiala. Michael Fiala appeals under the authority of Section 76-6 of the Charter of City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the Cleveland Landmarks Commission to issue a certificate of appropriateness in case number 25-050 for renovations at 3801-3815 Lorraine Avenue on August 28th, 2025. And with that, I'll hand it over to Ms. Roca for the oath.
Thank you, Ms. Holzer. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and give your address.
I do. Michael Fiala, MICHAEL FIALA. I live at 2027 West 38th Street. I do.
Thank you.
I do. Lauren, Loren, Gordon, Gordon. I'm not a.
And can you repeat? You're going a little fast.
Okay.
LAREN.
Loren. Well, I do. Yeah, let me say I do again. Loren, Gordon, Gordon. I'm an attorney. Mr. Fiala asked me to come, so do you still need my address if I'm not a
No,
resident?
you will be testifying,
Right.
correct? You're here to represent your
Yeah.
client. Yeah, we don't need you to swear in.
I do. Dan Musson, MUSSON, Secretary of Landmarks Commission, 601 Lakeside Avenue.
Thank you. Anyone else in the room? It looks like we have people on the call. Okay, go ahead, sir. You're on mute.
Yes, I do. Christopher Toddy, CHRIS TOPHER TODDY. Address is 820 West Superior Avenue, Suite 425, Cleveland, Ohio 44113.
Thank you very much. Anyone else on the call? I'm not seeing any other hands raised, so back to you, Madam Chair.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is appealing a decision of the Cleveland Landmarks Commission. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, who would like to speak first? Go right ahead, state your name and give your comment.
My name is Michael Fiala. I lived for almost 45 years at the house across the street from where the proposed Noble Beast Beer Garden project is. I don't just represent myself today, but 29 other immediate neighbors on West 38th Street within 400 feet of the proposed project, and many other neighbors besides. I love my street, neighborhood, neighbors, the near West Side, and I have a long, beautiful history there devoted to its care, vitality, and redevelopment. I come today before you for your help in addressing significant issues regarding the Noble Beast Beer Garden proposal, which received a certificate of appropriateness from the Landmarks Commission at its meeting August 28th, 2025. I was directed by city representatives of the commission to the Board of Zoning Appeals when I sought to appeal the decision. The purpose of this appeal is a request that BZA review Landmark's decision and rescind or put on hold the certificate of appropriateness given to the Noble Beast proposal. By doing that, BZA would require the issues regarding project design and meeting city ordinances that I will summarize be addressed and resolved. Or if the proposal fails to do so, deny the certificate. So would you like me, Madam Chair, to describe all the issues first, or would you like to hear each one at a time and then you respond?
You can just give your testimony. You can describe the issues that you see fit, and we'll ask questions if we
Okay,
have them.
great. And at the end, I'd like to have a last opportunity to speak when we come to an end of our conversation.
Okay, it looks like your attorney wants to chime in, please.
Are we under any time constraints?
Yeah.
It's a loaded question. So it's a public meeting, so your client does have the right to speak. But if anything gets, repetitive, then we have to stop you and move on, so.
So I realize it might be a challenge to follow the issues without extensive details. I'm trying to be brief, to the point. Generally, the Landmarks Commission mentioned these issues, but did not address them sufficiently or resolve them. So, for example, the 500-foot rule. The Noble Beast proposal falls within local retail business district zoning. And per ordinance, establishments that provide entertainment or where beer and intoxicating liquor are sold for consumption on premises cannot be located within 500 feet of a school, church, library, nonprofit, recreational community center building, or public playground property. The Noble Beast proposal is within 500 feet of Frank Novak Park and Playground, the Cleveland Public Library Carnegie West Branch, and a child care center, Escuelita de Ohio City at 3919 Lorraine. A variance is required for the Noble Beast proposal to proceed and has not been issued. Reasons have not been offered for a variance to be granted. So that's the first point there. Number two, PRO street line. The Noble Beast proposal property is in the pedestrian retail overlay district. Quote, no main building on a lot abutting a pedestrian retail street frontage shall be set back more than 5 feet from the pedestrian retail street frontage. Unquote. So buildings are to hold the street line. The Noble Beast proposal has a 15 feet setback and a 55.5 feet setback. The 55.5 setback needs a variance. It's not been issued nor addressed by the Landmarks decision. There's also a window requirement described in the documentation. I'm not going to elaborate on that because I think it's a little more technical than needs addressed in this particular setting. So I'm going to try to be pointed and move on to the next. If you go to the next page, C on that document. Thank you so much. Removal of all parking requirements. The Landmarks Commission did not question the Noble Beast's claim that no parking is required. Per City Code 301, Transit-Oriented Development and Transportation Demand Management, the Noble Beast must submit a Transportation Demand Management TDM plan to the Off-Street Parking Committee. BZA should require a TDM plan and assess its validity. This requirement should be done before a certificate is granted and variance required to city code. The new ordinance of the city is not a blanket removal of all parking requirements. Think about the differences between a 150-person beer garden and a 6-person apartment building. These are vastly different kinds of things that should need, that's why a plan needs to be presented beforehand. For the following issues, the primary point I want to make, previous in the past one, previous ones, emphasizes that city ordinances focus on the well-being of the city as a whole for businesses and residents. Good design makes good neighbors. Ordinance need to be met. Residents' opposition must be addressed with meaningful adaptations and changes, or the project cannot proceed. City ordinances and design requirements are there to benefit all involved. Please hold this project to that fundamental design requirements that serve both residents and businesses. So, for example, meetings and recommendations from neighbors to mitigate noise and nuisance from the Noble Beast proposal have had a limited impact on the improved design. Noble Beast principles cite cost and design necessities with little or no further discussion to address the substance of the responses. The immediate neighbors on the street of Noble Beast proposed project, the effects on residences of this destination business, a 150-person outdoor beer garden, must significantly shape the design and legitimacy of this project contiguous to a residential neighborhood. So the final highlight there is that, or I should say one of the final ones, is that the immediate neighbors within 425 feet on West 38th Street signed a petition opposing this project. And when we requested that we be able to attend the Landmarks Commission meeting and speak, we're not allowed to do so due to a heavy agenda, understandably. But we felt like that the summary wasn't adequate to the opposition to this proposal. And when I spoke to Landmarks, commission member, councilperson Gray, in the hallway right after that session, she indicated that she didn't hear any, opposition. She simply heard concerns. And I said, no, there was serious opposition and I had submitted this information, but it wasn't, I believed, adequately summarized at the moment. So we had an extended conversation, Councilwoman Gray and I, and she said she'd note that to the commission staff. So the Noble Beast proposal fronts on Lorraine Avenue and West 38th Street equally. On West 38th Street, the Noble Beast would have a large garden patio and open air area, providing space for 50 to 75 people or more. The current plan reflects minimal design changes and adaptations to express concerns and suggestions. For example, the current design does not focus its open spaces greenhouse towards Lorraine Avenue, but continues to have a significant presence on the residential area, West 38th Street, and that petition expressed our opposition. I've also provided a link to the YouTube presentation and a transcript of the relevant details. So I repeat my request from the beginning. You now have the outline of the details. Chris Toddy and Lauren Gordon are here to provide some additional information and expertise. Again, I love my neighborhood. I've been there for over 45 years. We know one another. This is a true neighborhood and a residential area that is a crucial component to how we interact with resident businesses, especially new businesses. We want to welcome new businesses, but this one seems to be way out of line with relative to the residential neighborhood of the street. So I request that you address these issues and send or put on hold the certificate of appropriateness. And by doing so, allow for a better mutual design, or if not being met by a design that would meet all the requirements in city ordinances, deny that certificate. Again, like I request an opportunity before the final decision is being made by BZA, that I'm given the opportunity to make a statement. And again, thank you very much for your time and attention. It takes a lot personally for me to raise and spend all the time to really try to consider this seriously, but I'm devoted to this and I appreciate your devotion to your own work. Thank you.
All right, thank you for that.
And
would you like to
Chris,
speak next, or would you like to give it to Mr. Toddy?
Mr. Todd.
All right, Mr. Toddy, you have the floor.
Thank you so much. Good morning. My name is Chris Toddy. I'm an architect who lives in Ohio City and works in the city of Cleveland on various projects where I advise my clients on navigating the city ordinances. In this case, we believe the city ordinances have not been met, but they've been overstepped. And part of our urgency is that the building department seems to be about to give the project its construction permit without these issues being addressed. In addition to what Mike just mentioned regarding the variances needed on the project but seem to be overstepped, we're asking for your help in making sure that they don't be overstepped. I would say in relation to parking, zoning code 349.04F and A refers to required parking for this type of project. Then the PRO allows a reduction if the PRO requirements are met, which have not happened in this case. And as neighbors and as a local architect, I'm asking that parking be provided. None currently is provided on this project. I ask that parking be provided and justified otherwise. And then one variance that Mike did not mention that I'd like to mention is that as part of the PRO, there is a glazing requirement for new projects on Lorraine Avenue, and that has not been met. And I'm asking that variance also be taken seriously and be something that the developer be asked to come back to you. All of these variances come back to you for their offering of their hardships and a public discussion about these. Thank you.
All right, thank you for that. Chief Leonard, I did see that you put some comments in the chat. Is that something you wanted to bring to our attention? Because we can't see the chat any longer. I just kind of saw it flash up and go away.
Yeah, good morning. So there was some statements about the zoning code regarding the alcohol provision within 500 feet in 343.01F. Understanding that that particular provision limiting alcohol consumption within 500 feet of a school was specifically found to conflict with state statutes regulating liquor control in Square Deal Coal Haulers and Yardmen's Club versus City of Cleveland, January 24th, 1961. And the preemption of liquor regulation by local zoning was most recently reiterated in Westlake versus Mascot. The ordinance language being unenforceable since 1961 should have been removed from the Cleveland zoning code decades ago. So I just want to let you know that we cannot limit where alcohol is sold specifically in those local retail districts.
Okay, understood. Thank you so much for that. All right, attorney, do you want to give some comment?
A few things, yes. One is, I think, I don't think this, hopefully this is not an oversimplification, but I think the issues kind of divide into both procedural and substantive. The substantive issues are addressed very thoroughly by Chris Toddy and David Ellison, who are both architects, about setback, window glazing. I know Mr. Ellison, I think, quoted from some of the language about mass, sizing, and location, that type of thing, to make sure that this fits into the historic district. I was trying to think of some examples that would be vivid to help people kind of visualize things. And I was thinking about, years ago, I lived in Washington, D.C., and there was an area in suburban Virginia called Old Town Alexandria. And I think that's kind of an example. It's a lot of federal buildings. It's a mix of residential and some light retail. And it's beautiful brick facades and whatnot. And the point is that to drop something like the Noble Beast at this intersection would be like tearing Old Town Alexandria apart. There are times and places for things, and you just don't do it. So that's some of the substantive issues, and the process issues, one of which would have been what the lady just talked about as far as variances. I'm unfamiliar with that case law. I don't know if any of the members of the board are familiar with it as far as any state preemption. But I would ask and without having heard yet from Mr. Musson, I would ask that the board not vote immediately, because there are a lot of ordinances. There is the transcript, I think, is at least 25 pages long. I don't know if anybody's had a chance to review it yet. And I think it does take some time to digest all the testimony and the letters and documents that would be submitted. So, I think this is a little more complex than what you've dealt with earlier this morning in terms of just variances and whatnot for smoke shops. So I think it would behoove everybody to take a few days to review all the documentation, come up with a reasoned decision.
Okay, thank you for that. I'll turn it over.
If I might add one more item, or is that, I'll be glad to defer.
Okay, I'll turn it over to you, Mr. Musson.
Thank you, Madam Chair. I just have a few slides. And we are here this morning for an administrative appeal of Landmarks case 25-050. Thanks. Oops. As Ms. Cornelius summarized earlier for an administrative appeal, we're really looking at whether the Landmarks Commission acted under its ordinance authority. Did we follow our own rules and procedures and process? And did we act arbitrarily or capriciously? I feel like the appellant's issues kind of are more with the zoning code than the Landmarks case itself. As Landmarks, through our ordinance authority, is charged with considering the Secretary of the Interior standards for rehabilitation when determining whether projects adversely affect the historic nature of historic district or an individually designated landmark. Go through our process real quick. When an application is either submitted directly through our office or someone applies for a permit through the Department of Building and Housing, that kind of triggers our process. first step is, Landmark staff reviews it and determines what that process is going to be, whether it's something we can handle administratively or if it will need to go through our design review process. When it goes through the design review process for a case like this involving new construction or significant addition, they start with the local design review advisory committee. So in this case, the Historic Ohio City Design Review Advisory Committee. They present to that body and then to the Landmarks Commission, both schematically at first, and then return for a final review both to the local design review advisory committee and the Landmarks Commission for the final approval. And again, that is an approval of the certificate of appropriateness. It isn't the city's only review of a project. There are also zoning reviews and building code reviews that happen after the certificate of appropriateness is issued. We do have a process for public comment, which Mr. Fiala referenced. At the beginning of each of our design review advisory committee meetings and at the beginning of our Landmarks Commission meetings, we state and have up on the screen our process for public comments. And it's on our website and it's at the end of each agenda for both the local design review advisory committee agendas and Landmarks Commission. But in summary, you have to submit comment in writing 48 hours prior to a meeting. That gives us the opportunity to share those public comments with the committee and commission members beforehand. And then during each of those meetings, we summarize the comments. In a case like this, there was a good deal of comment, which I'll share some of later. But so, the summary, I'm sure, isn't going to capture it all, but that's why we share the actual comments with the commission or with the committee and commission members ahead of time. So real quick review of the process for this one. This case, it went to the Historic Ohio City Design Review Committee for schematic review on July 3rd, then to the Landmarks Commission for schematic on July 10th. Kind of during those meetings, one thing that came up a lot in the public comment we received was sort of a lack of community outreach on the behalf of the developer. So the commission and the committee both encouraged them to kind of meet with neighboring residents and business owners and make them aware of the plan and just have a meeting with the community. So that took place through Ohio City Inc. on July 31st. And then the applicant returned to the Ohio City Design Review Committee on August 21st, 2025, and then Landmarks Commission on August 28th, 2025. During the schematic level review, their discussion of some of the issues raised by the public, some of them related to the sound mitigation and siting of the property or of the proposal. There's a commitment from the developer to engage the neighbors, which is, what that July 31st meeting was. There's also a lot of discussion of the period of significance and the history of the site, and the fact that this was, I guess, has been a vacant site for a number of years, and that it was a gas station or service station for about the last 100 years. So the appropriateness for this site might not be the same as if it was a building that was built up to the property line and demolished last year. As noted, there was a lot of public comment received, almost 100 public comments for the schematic level review, and then roughly another 20 or so for the final review. Again, these were all shared with the commission and committee members prior to the meetings and then summarized during the public meetings. Went to final review at the local committee August 21st, Landmarks Commission August 28th. As noted, the commission voted to issue the certificate of appropriateness, which was then issued based on the pending permit on September 8th. 2025. As noted before, that we're not the only step in the approval process for the city. After Landmarks Commission approves something, it continues through the city's review process. But we do like to have an idea of what some of the issues are. So we had a zoning evaluation completed by Chief Leonard before this went through the final review process, just to see if there were any zoning issues that we needed to be aware of that might impact the design of the project. None were flagged as being out of compliance or needing variances. So our feeling is we acted under our authority, we followed our rules and process, and we did not act arbitrarily or capriciously.
All right, thank you for that. Can you go back to your earlier part of your presentation that sort of outlines your process and, you know, what you all do as you're making a decision? I want to give the appellant and perhaps Mr. Toddy another opportunity to address the issues that we have before us. So I know that there were a lot of concerns regarding zoning raised, but the real bulk of the decision that was made by the landmarks body relates to this process. So is there any issue that you all take outside of zoning issues with this process?
I think I would highlight this, that I was directed by the city to address BZA for my appeal. It seemed like to me that would be the relevant place in which to bring these issues. I'm confused if it's not. Part two is, I think the issues of the summary of the letters, there was not a distinction between letters sent from downtown Cleveland and way outside of the neighborhood versus neighbors sending it. So this kind, and then specificity of content. So I believe content was not adequately heard, and I cited a clear example when Councilwoman and Landmarks Commission member Gray did not hear any of that opposition. It was concerns. So I think content wasn't adequately presented. I think there are additional issues, and I don't know that I'm like the level of expertise to be able to speak to that. That's why Chris Toddy and Lori Gordon would be for that.
Okay. Mr. Toddy, you want to chime in?
Yes, please. So this project was reviewed by Design Review, and Design Review had a number of comments. During the conversation, they asked the developer to work with the neighbors. The developer had a meeting at OCI with the neighbors. During that meeting, I was able to present an alternative to help in the conversation to try to move the noise away from the neighbors and towards Lorraine Avenue. The project is at the corner of West 38th and Lorraine. So included in my letter and David Ellison's letter is contribution to engage with the developer to try to mitigate the noise. We feel as neighbors that the developer did not, in good faith, try to work with us, that they utilized the public meeting as something to check off on a checklist rather than engaging in a project to make it a better project for the neighborhood and have it be a win-win. I guess I take issue with Mr. Mussin's representation that the city has sufficiently reviewed the variances needed, and I'm asking this board to consider whether the variances we submitted are significant enough to overrule the city's internal approval process and allow these variances to be heard. Thank you.
All right, thank you for that. I'll give you a last opportunity to make comment if you have any.
Okay, thank you. And I know that Mr. Fiala has, I think, 2 things he'd like to say. That's all right.
Okay, you have the floor.
Okay, thank you. Getting back to my distinction between process and substance, correct me if I'm wrong, but I believe that a lot on the substantive issues under the landmarks ordinance 161-05B2I is the real meat of this. It says the new work shall be differentiated from the old and shall be compatible with the massing, size, scale, and architectural features to protect the historic integrity of the property and its environment. And I think for the board to really come to grips with that, it would require sitting down and looking at the transcript and especially the drawing, to see why my clients don't feel that the Landmarks Commission did a thorough job on that. So I think that's all I had to say.
All right, any questions from the board?
Yes, Madam Chair, I have a question for the appellants. So your burden here today is to prove that the Landmarks Commission's issuance of the certificate of appropriateness was illegal, capricious, arbitrary, and we do need to hear testimony from you indicating why you believe that their issuance of the certificate was in fact illegal, arbitrary, capricious, and I don't know that I've heard those facts yet. So I'd like to give you an opportunity to make sure that, we're not, this is not a zoning variance issue today. We're not here on a zoning variance. We're here because you allege that the decision was illegal or capricious, and so you need to meet that standard. So I would open the floor to your testimony on how in fact the issuance of the certificate was illegal, arbitrary, capricious, et cetera.
And I thought I was speaking to those issues. And I'm translating it into illegal, arbitrary, and capricious. I'm not sure how I would adequately do that. But I do believe when you have the kinds of issues that have been raised, like a certificate of appropriateness means that all the steps have been addressed. One of them is the transportation the terminology. Let's see at this moment, but the transit-oriented development and transportation management plan, that seems to be a foundational need, and it is not being presented and hasn't gone through that process. So it seems to me that that's one example of not following through the responsibilities, whether it fits in illegal, capricious, or arbitrary. I'm not sure how that can be defined as an example. The pedestrian retail overlay district, I was involved 13, 15 years earlier when there was a McDonald's that wanted to go in, where now there is a Metro Dental Clinic. So they were held to a standard having to do with the pedestrian retail overlay district. That McDonald's is not there, but rather the Metro Dental Clinic, which is an asset to the neighborhood. So I think those are examples I'm trying to cite that highlight it. I think the adequacy of representing the neighborhood in our opposition, when you have letters and letters and letters, none of the designations of where those letters were from was highlighted. They didn't say, oh, here's the people from the neighborhood. And so it seems to me content wasn't adequately addressed in a way that would be specific enough for the board to reflect on. It seems to me it doesn't then follow that you should get a certificate if you've not met all those standards. How you fit it into those categories, I'm not the expert to do that.
Okay, thank you. And then follow up to that, Ms. Leonard, if you could speak to the zoning review that was completed, is it the testimony of the city that there are no variances that were needed for this project?
I would have to go back and look at the review, but I believe that there were no variances required for this project. But I also just want to highlight that the variances that the appellants are discussing here today are not related to the appeal of a administrative decision by the Landmarks Commission under Chapter 161.
Yes, and that's the kind of the point I'm getting at. So the Landmarks Commission makes their decision on the Secretary of Interior standards. So what I guess I'm looking for from the appellant is what, under those standards, you're saying they made a mistake. How did they make a mistake? How did they not appropriately issue the certificate under the standards in which they have to follow by the Secretary of Interior?
My question would also be, if city ordinances are not being followed, who do I go to? I was directed towards you, and therefore I'm here. Who in the city makes the businesses follow those city ordinances that I'm citing? And so I'm here to ask you to do that. And it seems to me to be irrelevant to stay or put on hold this decision or rescind it in the short term so that these issues could be further investigated and heard more thoroughly.
So let me ask you this, Secretary Muzzin, when your department reviews a decision where you would issue this certificate of appropriateness, is it within your purview to address zoning compliance or failures?
No.
Okay. So it sounds like it's something that you had just done to sort of be proactive, but not necessarily anything that you were required to do.
Correct.
Okay. And then question to Chief Leonard. There are a few issues on the table with regards to the zoning in this particular property. There's been several things stated, such as there is a 500-foot rule where this brewery should not be within a certain distance of child care centers, schools, and playgrounds. There's also an issue stated regarding the PRO district where the setback is beyond 5 feet. There's also issues cited regarding window requirements and parking requirements such that a TDM study was not submitted. So it seems the appellant is basing the appeal off of these issues which strictly relate to zoning. Is there a separate process that this project would need to go through in order to address these issues?
Yeah, so I can address those issues now. So first and foremost, the 500-foot rule, as stated in the chat, is not enforceable and has not been enforceable since 1961, per the former Chief Zoning Administrator, Richard Riccardi. As it pertains to the transit-oriented demand management, it is in a TOD zone, but the addition is less than the 5,000 square foot that requires a TDM plan to be approved by city planning. And then as it relates to the PRO district and the setback, there is a modification permitted for an entrance to be set back greater than the PRO setback. And then as it pertains to parking, again, there's no minimum parking requirements in a TOD zone. And there is no TDM plan needed when the square footage of the addition is less than 5,000 square feet.
Okay, that is super helpful. Any other questions from the board based on that?
Madam Chair, I tend to agree with Ms. Roca is that comments have been related more to zoning and design issues than perhaps the answering the burden of proof for a judgment on the ruling of the Landmark Committee. So I'm wondering if perhaps just for the benefit of the, I think the explanation that Ms. Leonard just gave was helpful, but I'm wondering if she perhaps can't clarify for the appellant that what the next steps might be in the project so that they could better address their concerns to the appropriate department.
Well, I think the problem that Chief Leonard is stating is that these concerns that have been raised legally do not stand. And she just gave us an explanation of why that is. Specifically the 500-foot rule is not enforceable, and she cited case law regarding that. She also stated that there's a modification permitted as it relates to the PRO district setback. And then finally, there's no TDM plan needed. Although it's in a TOD zone, the plan is not needed based on the size of the project. So I think the problem is the issues are raised, but Chief of Zoning disagrees with the issues that have been raised. So Mr. Toddy, I'll give you one final opportunity to comment before we go to vote.
Thank you for that opportunity. So this is an outdoor beer garden, and so if you include the outdoor area, it's over the 5,000 square foot limit, and so the TOD should be considered. And second, as part of the process by the city, this went through its process where there was an internal review saying that it did not have any variances. Landmarks seemed to approve that, and because they approved that and moved past Planning Commission, We have no other recourse than to ask for your help to send this back to Planning Commission. I'm saying that the landmarks decision was capricious in that they skipped a step, in our opinion, and through the significant variances we have presented here, that it should be, the variances should be considered. And it was Landmarks that was the public entity gatekeeper of that, and their decision bypassed the Planning Commission.
All right, thank you for that, Mr. Toddy. Chief Leonard, is there any response to the comment that was just made that there's some additional footage that should be considered given this is an outdoor beer garden?
So we don't normally, as it relates to the TDM, add the square footage of outdoor patios, if you will. The additions on the buildings comes out to roughly 2980 square feet, give or take a couple feet. And so that is under the 5,000 square feet. And as such, there's no TDM plan required.
All right, thank you for that.
Madam Chair, I have one more question for Ms. Leonard. Ms. Leonard, can you also speak to this, I think this is the first fact I've heard where the appellants are saying that the decision of the Landmarks Commission was arbitrary or capricious because they skipped a step. Can you speak to that testimony, whether the city, what your testimony is as to whether the city skipped a step in the process?
Thank you, Chair. So the issue here would really relate to Dan. You'd have to ask him about their process. I believe that process was followed. There was no reason for this to go to city planning. No conditional uses were required as it pertains to the pedestrian retail overlay district. So if there's a contention that there is a conditional use that was missing, I haven't heard it yet.
Same. We'll give you an opportunity to reply to that as well, Secretary Mustin.
Yeah, thank you, Madam Chair. Yeah, no steps were skipped. It's just the normal process that projects, and in this case, it was through a building permit application. They go through, like, we're essentially the first step. And it goes through our process, and then it goes on to zoning, and it goes on to plans examination to review under Ohio Building Code. So yeah, we went in the normal order of things and issued a certificate of appropriateness so that it could undergo those other reviews.
So it's appropriate to say that this will be forwarded to the zoning department for a review on the zoning compliance or not?
Yes, yeah.
Okay, okay. And then Chief Leonard, it's also appropriate to say, once it gets to your office, if there are any variance requirements, then the project would not go forward. In fact, they would receive a letter of nonconformance. Is that fair to say?
That's correct, but I believe that a zoning review has been completed on this project.
Okay.
And no variances were found.
Okay, understood. All right, any other questions from the board?
I have nothing further. I think we've satisfied the questions that we've had.
Okay, very good. I'll give you one final opportunity to comment.
Thank you very much for your time. I do feel I need to reserve the right,
You always have appellate rights.
Okay.
So even if you do not agree
Yeah.
with our decision
Yeah.
here today, you still reserve that right to appeal.
Thank you for your time.
Okay, any final comment?
Yeah, thank you. One is that Mr. Fiala and I were checking as late as last night to see whether this was posted on the website. I don't know if it was. And, I won't get into the legalities of possible consequences of it not being posted, but I just wanted to throw that out.
Posted on which website?
On the board's website, where they have that little box that says, I think it was still listing November 3rd, the November 3rd agenda. I don't think I didn't see today's agenda as late as last night on the website.
Okay. Can I have you speak, Madam Secretary, to the notice that has been given regarding this meeting?
So we do send out the agendas to a master list, and it is communicated with the person that posts it in the City Planning Commission through that same email. We have had issues with internet and there were some things being switched to a SharePoint to a new sharing service. There could have been an error. Honestly, once I send it, I don't always go back and check to see if it's been posted. So I could research that and find out what happened and if there was an error, if there was some issue there. Now, we send out notice to the city representatives and we send out notice to the applicants within 2 weeks before the hearing. If you would like us to research that, Madam Chair, and to find out if the posting, we are required to post these things 7 days before the hearing. We also do post them. I should state that these things are posted in the city record through the city council. So that's another public forum where we can post, where it is posted regularly. So I can confirm that. I can find out if that was posted timely or not. But the code requires 7 days before the hearing for it to be posted.
Okay, so it's been posted and it's also been mailed out to the neighbors as required. Am I hearing that correctly?
I can
Okay.
confirm if you'd like me to get back to you on that, but we did also send it to the city record. So there are 2 places that we post it. It's in the city record on our website, and then it's mailed to the applicants and the city representatives, 2 weeks in advance.
Okay, got it. Thank you. Chief Leonard, I can see that your hand is raised. Do you have additional comment?
Yeah, the code requires just that in the city record that it's posted. So if it was posted in the city record, it is per the legal requirements. The internet is normally a way to be a courtesy in the 21st century.
Okay, that's what I was getting at. Thanks, Chief Leonard. All right, any other questions from the board? If not, I will entertain a motion.
Make one other comment, please.
One final comment.
Because I think the transcript is such an important part of this, the transcript from the landmarks hearing. My client is almost in the position of having to prove a negative. The transcript's somewhere in the neighborhood of 25 pages, maybe 30 pages. I think we would literally have to go line through line to show where landmarks failed to address something or failed to address it properly or thoroughly. That puts my client in a very difficult position of having to prove a negative. And I don't want to sound like a broken record, but again, I would really urge the board to table this for a few days until the members could read that transcript and see if it really measures up to the landmark ordinance.
So just so that you know, in terms of the process that this board follows, we internally receive documents that are put together by our secretary, our amazing secretary, and she gets those to us in advance. And so every board member has the opportunity to review all of the materials that will be presented in advance of it being presented. So we have the transcripts. We have access to the letter that Mr. Fiala submitted, the letter that Mr. Toddy submitted. We have access pretty much to, everything that we need to make a decision. And it's your burden as the appellant to come in here and say, this is exactly why. And it's your burden to point to where in the transcript would there have been a misstep. And so we've opened up the floor several times for that type of testimony. And I think we've heard plenty for us to make a decision at this time. Okay. If there are no other questions from the board, I will entertain a motion.
Madam Chair, I will just note that I did review those documents and printed them out. So just to assure the appellant parties that we received them, they have been received and reviewed by the board in advance of the meeting.
Absolutely.
Was that Ms. Faith speaking?
That is Ms. Faith. Yes. All right. I'll entertain a motion.
Madam Chair, given the testimony we've heard today, statements by Ms. Leonard and all of the statements by the parties, the appellant parties, I move that we uphold the decision of landmarks on calendar number 25-187.
All right. Thank you for that, Ms. Faith. Is there a second?
Board Member Holzer, I second.
All right. Thank you, Ms. Holzer. Can we call the vote, please?
Ms. Roca?
Yes.
Mr. Madison? Ms. Holzer?
Yes.
Ms. Faith?
Yes.
Ms. Wilson?
Yes.
Count number 25-187 is denied. The decision of the Landmarks Commission has been upheld. This decision will be ratified next Monday, and we will send the appellant a letter.
All right. Thank you for that. That concludes that matter. We'll now move to calendar number 25-196. Do we have Rodney Johnson available?
Yes.
All right, we'll have you come up to the table, and while you do that, we'll have Ms. Hoser read in your case.
Okay, I'm also here, Stanley Johnson.
Okay, this is noted. Thank you for that.
Our next case is calendar, oh wait, I'm seeing it as 25-196, and is it 196 or 187?
Yes, one.
Oh, okay. Okay, just noting that, error on the slide. Our next case is calendar number 25-196. This is at 9804 Quebec Avenue. The appellant is appealing the decision of the Commissioner of the Division of Water Pollution Control. Rodney Johnson, owner, appeals under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the Commissioner of the Division of Water Pollution Control regarding maintenance of a water sewer connection at 9804 Quebec Avenue and the owner's responsibility per Section 541.30. And this was filed on August 18th, 2025. With that, I will hand it over to Ms. Roca for the oath.
Thank you, Ms. Holzer. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and give your address.
Okay, I do. Rodney Johnson, Rodney. Johnson, Johnson. Address is 9844 Quebec Avenue, Cleveland, Ohio, 44106.
Thank you very much. And we will go to the individual on the call. Mr. Johnson, if you can do the same, please.
All right, the name is Stanley Johnson. Spelling is STANLEY, Address 9804 Quebec Avenue. I do.
Okay, thank you. And then I'll start with you.
Yes, how you doing?
Good.
Maurice, Maurice, Grayer, Grayer, and I do.
I'm sorry. Go.
Grayer.
Okay,
12302 Kirby, I do.
thank you.
I do. Ryan Lopez, Ryan Lopez, the Commissioner of Water Pollution Control, and we're representing WPC today.
Thank you. And you're 601 Lakeside?
No, I'm sorry, we're 12302 Kirby Avenue.
Okay, thank you. Anyone else on the call or in the room wishing to speak in this matter? I'm not seeing anyone, Madam Chair, so back to you.
Thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is appealing a decision of the Commissioner of the Cleveland Division of Water Pollution Control. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by a preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right. Which of you would like to go first?
Well, I can, I'll lead it in, and take it over from there, okay?
All right, go
Let me
right
state
ahead.
the
State your
problem.
name and then give your comment.
Rodney Johnson. I've been cited for a broken sewer line on my property. And I have a sinkhole. And problem,
Did you say
a
sinkhole?
sinkhole
Okay, thank
in my
you.
front lawn. And it appears that the problem originated from improper sewage drainage on the street and causing the problem on my property and resulting in the damages to the property. So my brother has some information to share with you also.
All right, Stanley Johnson, you have the floor.
Thank you very much. I sent in a video earlier, okay, outlining the issue. And because I'm not much of a speaker, though, I have created hopefully a method where I can get this here understood for everyone to see it. I know everyone don't have probably the video handy, but I did send some flyers or photos to the Board of Appeals. So what I'm going to do, if it's okay, I want to do a read aloud on this here sheet, which is pretty much the same thing that's in the video. And the individuals that's following along with the flyers in front of them will be able to to exactly what it is I'm trying to get across. So let's see what happened here.
Excuse me, Madam Chair. That's correct. We did receive the video. There was an issue when we tried to live stream with video prior to this hearing, so we advised the applicant, for us to actually see their slides, be better to just receive a PDF of the slides so that we could actually go through the entire presentation. As video feed has issues when we try to stream it through live stream.
I provided the Board of Appeals with hard copies of the photos, which I have copies here as well. I PDF'd them, understanding that they were going to copy those and send those to the interested parties. So I'm assuming that everyone has viewed the video and have in their presence right now those photos that were sent to the Board of Appeal, the Appeal Board. Is that right?
Yes, do you want to talk us through the reason that you feel this appeal is necessary?
Yes, because the codified rule, as I've got outlined here, now again, because it's sort of involved, I'm going to let you hear how I have it broken down. So I'm sure you'll be able to hear it.
Is Mr. Johnson playing a recording that we are unable to hear?
Yes, yes.
We don't hear anything right now, Mr. Johnson.
Okay, all right, I'm hearing it fine over here. That's going to force me to have to try to read all of this here. Is that what you want?
We want you to present your case however you see fit.
Madam Chair,
Okay. Well, I
Madam
thought,
Chair, are these photos, the video was included in our packet, which ran about 17 minutes.
yes.
And I believe the photos were included in our packet as well. Is that correct?
Yes, this is correct.
Okay, all right. So we have viewed what was in the packet for us, just for the benefit of the appellant, so he knows that we've seen this information.
Okay, that be the case, other than what's in that video and the narration that goes with it, all the evidence I have to hear is just to repeat all of that, and that is 17 minutes, like you said. So I would be happy if you just go ahead and review the video, the evidence as it is, and make a decision. My brother was there. He's currently the owner until such time I purchased the property. Any other questions you may have, you can ask him.
Mr. Johnson, let me ask you a question. So it's your position that this issue that you have in the front yard of the property is due to the city's neglect of their sewer lines. So I guess my question is, if the problem is showing up on your property, so that's the part that you're responsible for. So how then would the city be liable for any of this? And this could either of you can address this.
Okay, let me take it, let me tell you exactly how the video is going to explain it to you. The video talks about. Hello?
Yep, we can hear you.
Okay. Quebec Avenue runs from 105th Street down to 97th Street. Quebec is on a hill coming from 105th Street, and Quebec is also intersected with 100th Street. So 105 and 100th Street are both hills. They enter an intersection at 100th Street. This water coming down this street during the rainfall, and we've had quite a bit here recently. The water comes down past 9804. At 9804 Quebec Avenue, the street flattens out. There are no drainage systems there. The drainage systems at 100th Street have been clogged, dilapidated, and water has pooled in that area on 100th Street. If you got those flyers, you'll see that it has on one of the flyers, it says intersection 100 and Quebec Avenue. And it shows the water and the debris that's in that area over the next two flyers. So these pictures was taken going back as far as last year, 2024, when I first noticed the sinkhole. Had a contractor come out and look at it and find out it was not quite what the letter said, in which I agreed. So I've continued to take pictures. Now, what is happening is, as that water comes down Quebec Avenue, and it settles in front of not only 9804, but a couple other properties, the water starts to seep from the street under the curve. By coming underneath the curve, it ends up into the tree lawn. In that tree lawn is a utility manhole. This utility manhole sits only about 18 inches from the sidewalk, and it's been a new sidewalk put there. Now, this here conflicts with the 541.03 codified rule, the 1 foot from the curve. We're all the way into the curve, all the way past the curve. The utility manhole is only 18 inches from the sidewalk. This manhole has collapsed below the surface. By looking at the top of the manhole, you can see how it's on an angle. So what's happening is the water is coming underneath the curve into the tree lawn, filling up that void with water. That water in that void, because of the dilapidated manhole, that water fills up as high as the street inside that manhole. But because it's raining, the water that is coming down on the grass continues to fill this manhole all the way to the top, to the level of the lawn. At that point, that water travels underneath the sidewalk, and from now, the sinkhole starts with water coming in from the top, as well at the base of the manhole that is dilapidated inside the tree lawn. So this is how the manhole is formed. The sinkhole is formed. And it all starts because there's no water being caught by the drainage system of the water coming down Quebec Avenue from 105 and 100th Street, intersecting at 100th Street and coming down the flat ground and starting to seep underneath the curve between the street.
All right, does that conclude your comment?
Well, outside of reading the letter to you, which you have in hand, where it states that the measurements were taken 28 feet from the manhole. The manhole, I measured it, and so did the owner. We walked it off. It takes 50 feet to get from the main manhole to the utility manhole, because it's a 90-degree turn from the middle of the street, from the manhole to the utility hole. So you got 50 feet there. Okay, with the 1 foot from the curve, the utility manhole is at least 2.5 feet past the curve. The manhole is WPC's responsibility. So because of the situation, the responsibility of the damaged manhole is not the property owners, but WPC's. So the language in the letter does not comply with the actual facts. So that's where the problem starts as far as the letter is concerned. But the problem is because of the water coming down and there's no adequate drainage system for Back Avenue to handle that water.
All right, thank you for that, Mr. Johnson. I'll turn it over to you. Please go ahead with your comments.
Thank you, Madam Chair. First of all, I want to say sorry to Mr. Johnson for what he's going through because we're here to serve our people and he's one of our residents. And so our job is not to cause enemies with our constituents, but it's to help them in any way that we can as long as we follow the guidelines and the jurisdictions that we're mandated to cover. So when I first got a call in the summertime, I don't remember the month, I want to say June, July, Council President Griffin reached out to me and asked if we can investigate the situation. Because as you could see in the photos, it's pretty lengthy tree lawn, sidewalk, then front lawn with fence. Obviously, we don't work on private property. We go a foot into the curb. And so I decided to go out there along with Mr. Greer. Mr. Rodney Johnson was not present, but we did speak with Stanley and I was trying to understand what was going on. And we do have tree lawn mains in some areas of the city, but this is not one. So the manhole utility cover that is on the tree lawn is Cleveland Water shut off, which has nothing to do with sewer. And I tried to explain that to him. He explained to me about the storm runoff, which I agree. There is a storm runoff because it comes down a slope, a hill, and they are at the low point, which obviously our catch basins are further down the road. Now, I don't know who put the sidewalk in. I don't know who put the sloped intersections in for them, you know, and the crosswalks. So there is water that puddles there due to grading of the street, which again, we don't do. That would be a street department issue. So although we are all city, I only have jurisdiction, only certain things, right? So I tried to explain that to Mr. Stanley. We talked for a little while. We just began to play tennis. And I thought, you know what, rather than us both get frustrated and aggravated with each other, have your brother call me or call Maurice is my customer service manager, and we could set up a time to talk and figure this out together because we do have partnerships with Cleveland Housing Network and other people that can help in a situation like that based on age, based on income. So we didn't want to just leave them, you know, high and dry. And so Mr. Stanley did explain that water coming from the crack of the low point of the curb was seeping water down. And I explained to him, I said, well, your tree lawn is not disturbed. It would affect your tree lawn before it goes onto your property. So I told Maurice, I said, have it cameraed. So we cameraed his house connection from the main sewer in the middle of the road. And we cameraed to where the sinkhole is in his front lawn, and we saw broken pipe. And so that's what instituted the letter of homeowner responsibility, and then to give him a letter saying you have to get this fixed because I got people contacting me like council president, schools in sessions about to happen. They didn't want students playing around the area on their way to school and from school and anyone falling and getting hurt. So on the neighbor side, because there's another picture, again, on the tree lawn, there is a utility, but again, it's a CWD. Our big brother, Cleveland Water, and we have no jurisdiction over those covers. So that has nothing to do with sewers. That's a separate cover that allows CWD, if necessary, or have to go in and shut off water going from the main sewer, from the main for water to the house. That, again, that's a separate system that has nothing to do with water pollution control. And that's, again, what I tried to explain. I left Mr. Rodney a message. Maurice had left him a message. We did set him up with Cleveland Housing Network with our contact over there. I believe, Maurice, if I correct me.
They never returned the call.
So there was never any return calls. So I hate that it had to come to this. Well, we could have handled this very simply another way, but I understand that, right? I don't discredit what, them coming here and appealing, but again, it's not a jurisdiction for WPC. And so we only denied it based on the broken pipe is on the front lawn area. And that's why as it rains, it continues to wash and erode the dirt in the front lawn.
Okay. Were you going to ask a question?
I was, Madam Chair. What is the penalty for the violation notice? What is the monetary penalty?
Well, there's not necessarily a monetary penalty, but we can have their water cut off until they do. We have a partnership with water that if they don't respond to the letter that Maurice sends out, there's a 30-day letter, there's a 60-day letter, and then we go to cut off of water because obviously your sewer operates based on your water intake.
Right, so if they aren't able to, what I'm hearing is, and I would like you to confirm, if they're not able to fix this pipe within 60 days, then you're gonna shut off their water?
We can't shut off their water, but we try to send them to our resources that we utilize, like Cleveland Housing Network, so that they can get assistance, because if they're elderly and they're on a fixed income, that's what we do. So we have multiple agencies that we can work through and try to resolve the issue and get them help that they need.
And approximately how much would it cost in your, knowledge of these issues, would it cost for the homeowner to fix something like this?
Well, I mean, it could be anywhere from 2 to 5 to 6 to 10,000 based on how much pipe they got to repair and how much excavating they have to do of the dirt.
Right.
And then, of course, there's a fence, so that it would probably be in the area of
Right.
the fence. And
Yeah, so is it your testimony that 60 days is enough time to get a contractor, remove a fence?
No, we just need a plan of action.
yeah, plan of action. So the letter says contact Maurice within 7 days with a plan of action. And if you don't have one, we will assist you in coming up with a plan of action. So it's not necessarily get it done in a 60, we send a letter after 30. So when we initially send an inspector out there and we determine it's a homeowner property issue, and then when we televised it, we have these little notices that we give for maintenance. We give them to our inspectors, they deliver it to the property. If we don't hear from them in 30 days, or we continue to, our inspectors are out there canvassing the areas they work in every day. If they notice there's still an issue, they get with Maurice. Maurice sends a 30-day letter saying, call me with a plan of action. If we don't hear from them by 60 days, then we send a 60-day letter. And it used to be 90, but we cut the 90 out. And then we send a notice to cut off. And that's when we get most of the calls. So we just don't cut it off blindly. We say, hey, contact us or your water's going to get cut off by such and such a date.
Yeah, Madam.
Are we in the process here? The homeowner obviously received a violation notice.
Mhm.
Did they contact your office?
No, they did not contact the office.
Okay, so they weren't given that opportunity for the 30 or 60 days because they never got back?
No, they were cut. Yeah, we did send them a 30 and a 60.
Oh, you did? Okay,
Yes,
you did send
and the first initial notice for maintenance.
Right.
Okay.
All right, I want to clarify, there was an investigation done and you stated you put cameras in sewage.
The main sewer, yeah.
In the main
Can you
sewer.
explain that a little bit? What you saw, where you found it,
Yeah,
all of those
so-
details?
So we drop, we have a truck and it drops, it's like, it's on the camera's on 4 wheels. And we drive it, so we launch it in, we drop it into the main sewer and we drive it to his house connection. So there's a camera on top of that go-kart, if you will. I don't have a better word for it. So as we drive it to the connection, we know his measurement based on our maps, and we launch a camera into his connection. So as that camera launches, it feeds and feeds and feeds all the way up. So usually, when we get to the curb, we know it's not a WPC issue because it's not a right-of-way issue. But a lot of times our guys will go the distance to see, and I obviously made sure you get as far as you can so we know exactly what the issue is. So when they got to the broken pipe, it was on the front lawn, beyond the fence, exactly where his sinkhole is. So that's how we saw. And we keep video of that.
Yes.
So, I mean, we're more than welcome to share that video with Mr. Johnson.
Okay.
Um,
What is the impact of the broken pipe? Is it like causing water to flow?
Well,
or-
broken pipe, as you use the bathroom, you use toilet paper, you use stool, it starts to form and catch. And eventually you can get away with it for a while, but eventually forms a wall. And so water will always find its way out, but it's just, it's what we release from our bodies that gets caught. And so as that wall is formed, then a broken pipe causes complete blockage. And then as you continue to use the bathroom, because obviously the pipe's long, so it's gonna fill up until the next thing you know, he sees it in his basement. Well, that could be 60 feet later, depending on how often you're using the bathroom.
Okay.
And madam, to that point, broken pipe, what's on the surface would pour into the pipe. So if it's broken, the dirt erosion will flow into the pipe,
Dirt
and
will
that's
just
how you
keep
get
washing away.
a bigger hole. So we don't want to see what happened in Florida to happen on Quebec.
Okay.
So, and the safety of the children as well across the street at the school. So children gonna be children. We don't want them to walk over there and jump into the hole.
Right.
So I just wanted, on the broken pipe issue, is that it's still connected to the main sewer line. It's just that the pipe from his property is just cracked or has a hole in it or something.
Yes.
Okay.
Yeah, so we're responsible from main to curb, and the resident or owner is responsible from curb
Curb
to
to,
out.
so the resident is responsible for under the tree lawn too?
Yes.
Okay.
I got a question.
Okay,
I
hold
just
on
want
one
to
second. Hold on one second. There was also an indication in the testimony that there's an absence of a properly functioning stormwater catch basin. Can you, either of you, speak to that and how that would impact?
Yeah, well, I mean, our engineers do reviews of all streets and infrastructure that we do and design. There's not an absence of stormwater drains. There's not one near where his property is. So as it comes down that hill from 105 on Quebec and it starts to, get flatter, it's just beyond going towards 100 Street. So there's no absence of stormwater drains. And again, a lot of the pooling that's taking place usually is a reflection of the grading of the asphalt. So as asphalt ages, it gets lumpy, and they do coal patching, they do fixing and repairing of streets. It tends to create, sometimes it could be a water flow issue, or water will pool during a rain. Which our trucks, we have backhaul trucks to any areas that's street flooding, any pooling that we have in the city, we try to get all our trucks out there. Obviously based on people calling, and then we know the high level areas that we need to address once once we're in a rainstorm, so.
Has this area been established as an area that needs to be addressed?
It hasn't,
Okay,
no.
okay,
We've never got any other complaints.
okay. Understood. All right, I'll give you an opportunity to give additional comment.
Reason of the complaints about 5 houses on that side of the street. So not that many houses on that street. So therefore, we don't get hardly no complaints except for the folks who had a problem. So we don't get a lot of calls in. I just got back into the country. I've been in Africa for the last year and a half. Last year. And so I came in October, and this was being addressed the problem here. More information from my brother. And that's why I wasn't getting anything. So, just a minute, sir.
Hold on, Mr. Johnson.
So, the hole, I put dirt in the hole. Okay, for safety. So the hole is filled. I got a contractor he's going to be, matter of fact, he pulling the permit this week, like Monday, last week.
No, we put it Friday.
Friday. So he's going to be putting the pipe in and digging the sidewalk and permit to dig. So that's in process right now. He said he's going to do it by Wednesday this week or Thursday this week, soon as get the permit to do so. So that'll be taken care of. But my main concern is that if the water continue to flow and begin to wash away the dirt, the problem is going to return. And if the manhole that is caught, if that's a problem.
That's a CWD shut off, yeah.
If that's a problem, the causing the problem with the property, then the problem will continue to return. Another year, 2 years, 3 years down the pipe, and another broken pipe. So I'll keep digging up sidewalks and continue to put pipes into the ground.
Well, it shouldn't cause pipe to break. Typically age causes pipe to break. I don't know when your house was built. But we can surely involve CWD to check their cover to see if their vault or anything is causing any issues on the property. It doesn't seem to me that it is, because if there was any issue with that cover on the tree lawn, it would cause your erosion to start on your tree lawn before it would happen back on your front lawn. So the front lawn is causing erosion because of the broken pipe. Once the pipe is repaired, you should have no issues. Now, if water's rising up in a torrential downpour that's going onto the property, I mean, that's something, again, we can have our engineers look at and determine if we need to put another catch basin on the road. And we can make that assessment.
Yeah, that would be a good, because for the last several years, and especially in the wintertime, when the ice begins to melt at the foot of my driveway, it just piles up there. The ice just piles up there tremendously because the water just freezes right there. So it's so hard to get that ice, to get it cleared out, to get my car out. And that was been going on for the last 10, 15 years. I thought it was just part of the winter there.
Yeah.
So,
And, you know, while we're empathetic to the situation, I mean, we can't just change the dynamic of the street either. And so we, you know, sometimes we get our backs to the wall because we can only do so much. And again, we collaborate with other divisions to get results for our residents. And that's what we want. I mean, that's my mission. I started entry level, and I don't take it for granted. And so to come up the way I did, and I appreciate, I'm a Clevelander. I appreciate people like Mr. Johnson, because we're here to serve our people. And so that's, if we can do something about it, we're going to do it. If we can't, we're going to be honest and say we can't. And that's just the bottom line.
All right,
Madam
Mr.
Chair.
Stanley Johnson, you had additional comment that you wanted to give. I'll give you the floor.
Yes, I do. Yes, thank you very much. Appreciate it. First of all, I'd like to start off. The issue is not a broken pipe coming from the property. Pipe is fine. Problem is,
No, it's
the
not.
sinkhole- the problem is the sinkhole started with the stormwater system, the water not having catch basins, standing in front of the house. Yes, the guy came out with a truck, with his camera in the hole. I sat there and I talked to him, and he said he ran the camera, but he couldn't get nowhere. He said he couldn't make it through the curb. I said, well, then the supervisor comes over and told the guy, said, well, I'll handle it, no problem. So he comes over and he gonna tell me, oh, it's it's your responsibility, 1 foot from the curb. I knew better, but I already talked to this guy who was running the camera. The camera has to go, yes, it probably travels, got a camera on it, and they can probably guide it, but it's got to go down the center of that street first. Then it's got to make a right-hand turn and come past the street, under the curb to the utility manhole. And because that manhole has collapsed, it's leaning in the tree lawn, and you can see that. You can also see from the video where that manhole, it shows where the manholes have filled all the way up with water. So that's water coming in not only from the street, but from the very top, from the grass. And water carries over underneath the sidewalk. And in the video, you'll see how muddy that sidewalk is. Okay, because not only is it doing it to the front yard of this property, but to the property next door. You can also look at the grass, and you can see that there's another sinkhole beginning to form right there in the tree lawn, because that part of the grass is not getting the nutrient, and so that grass is turning yellow. But where the water still is, the grass is dark green. So that's how another sinkhole is starting to form right there in the manhole, where the manhole is, until it gets replaced and maybe a concrete case put around it. That's the only thing that's going to support it. In order to run a dye test, they would have to do the same thing they did with the camera. And if the camera didn't make it to the curve, the dye wouldn't either. So there's a question there. So I would ask the appeal board to have those photos sent to you, the test, the actual test, okay, of the dye test and that camera run, because it will show that this claim, which is a boilerplate type of a claim, the ordinance, okay, it's just a way to kind of get the ball rolling. Well, now the ball is rolling. The situation that's stated in the letter The 541.03 does not apply to this case. Putting the responsibility on that entity that is required to maintain that street and the drainage system.
All right, thank you for that, Mr. Johnson. Any questions from the board?
Madam, excuse me. Madam Chair, I believe Mr. Lopez stated that he did not know who put in the new sidewalk. Is that correct?
Yes.
Is that something that streets would have done or?
It could have been the Bureau of Sidewalks. It could have been, another city division. I don't know for sure. Because they
Okay.
did they did, the four corners, the crosswalks as well with the sloped
Yeah,
slope down into the street. Yes.
yeah, for the ADA. Okay.
I have a comment.
So,
Hold on, Mr. Johnson.
Okay.
so my thought is this, there is the potentiality, I think, that maybe some heavy equipment on the land during the new sidewalk process could have contributed to some breakage or to some compaction of the soil that might have contributed to this. I'm also looking at the street and the depth of the curb seems diminished. And given the cracking of the asphalt on the street, looks like the street may be crowned, which also might be contributing to the ponding of the water in the area. It sounds like Mr. Stanley Johnson or Rodney
Yes,
Johnson?
Stanley Johnson.
Yeah, had indicated that you have a contractor coming to address the issue. But Mr. Lopez, I think what I would personally like to see happen is you partnering with the respective departments within the city to see if we can't take a look at the situation and remediate it on a more permanent basis. Since the homeowner is going to go to the expense of getting the sewer line replaced from the house, what is his responsibility. Let's take a look at what other components might have contributed to it and see if we can't get those corrected.
Well, I can speak to my expertise would say that no equipment or work being done on the surface of the ground would cause a pipe to break. And also we dye tested the hole and the hole was there before they started doing the work on the sidewalks. So, so that was not a contributing factor. And we did dye test the hole, which we normally would not do because that's out of our jurisdiction. But we did it because I said to do it because again, I wanted to make sure that the homeowner knew where the issue was and also we knew too, so that we would not be responsible for any issue as well. And so upon dye testing, we saw dye into our main sewer because when we dump dye and water down the hole, we look in our main sewer to see if we see green.
Right.
I saw green. So then we televised, and then when our guys televised Mr. Johnson's connection, that's when we saw the broke pipe.
Okay.
And then that's what,
and it falls within the fence, in between the fence and the front of the house, correct?
yes.
Okay. All right. All right.
Yeah,
So
because
I
when
guess-
our camera's up there, it's taking measurements. So we know how far our camera went, and so we kind of mark in green usually where the problem is. And so that way, the resident knows if it is a property issue. Obviously, we didn't mark in green because there was a fence there. And also it was, obviously pretty much gone. It was washed away already, so.
Yeah. So some serious subsidence. Yeah. Okay. Looking at the image that's now on the screen, the street does look crowned. So maybe we can work with, maybe you can get a hold of the streets department.
Yeah, we
See
can
if they
refer
can
it to streets
address
for
that.
sure. And I
Yeah.
told Mr. Rodney Johnson here too, we're gonna have CWD get over there
Yeah.
and take a look at those two covers they have on the tree lawn. Mr. Johnson's cover and the cover to the east No, I'm sorry, the west of his house.
Okay. Would you be willing, Mr. Lopez, or your, Mr. Grayer, to help expedite the process with CHN to see if we can alleviate, some of the situation with the homeowner for his repair work?
Sure.
Thank you.
Madam Chair, one thing I wanted to add, he mentioned that we aim to please our customers, but if we can't please them, we'll let them know, but we try to point them in the right direction to get them assistance. And as well, we want to help them. That's what we want to do. But if we can't get good communication, then we can't do nothing for you if you can't talk to us.
All right. Any other questions from the board?
I have something to offer.
Hold on, Mr. Johnson. This is a call for questions from the board.
Madam Chair, I think that's all I had. I think Mr. Lopez and his staff are looking to move forward to interface with the appropriate city departments and agencies that can help the appellant and the homeowner. I think their testimony satisfies the fact that the breakage is within the homeowner's jurisdiction.
All right.
Sorry, I just
Thank
have
you, Ms. Fay.
One
Go
last
right ahead.
question for Mr. Lopez. So it appears the appellant here is getting a contractor and going to fix the issue. You've done significant due diligence on your end to determine what the problem is from a technical perspective. The only thing remaining in my mind is the time frame that's going to be needed to coordinate all these things. One, for the appellant to fix the pipe. Two, for your department to coordinate with water and streets to make sure like the overall issues with water are resolved, because I do have some sympathy here for the appellant. If all of these things aren't fixed, this could continue to be a problem. Even if the pipe is fixed, the water pooling everywhere and not getting that addressed could still be a problem for him or any other person that lives on the street. So I just want some testimony from you on the record that you will be willing to take whatever time that is needed to work with all these various departments to resolve the issue, and that we're not going to be cutting off this appellant's water anytime soon.
Yeah, no, we won't be cutting his water off, number one. Again, we're here to make resolution. So as long as we know there's resolution coming, we don't just turn people's water off unless there's no communication. And that hasn't been the case so far since we've had to apply this SOP in place. So today I will make the necessary contacts. We will refer to water to check these two covers out on these tree lawns, and then I will refer to streets as well. And streets will go out there and do a grading, however they do to test their grading.
Okay.
So we'll get that done immediately.
All right, and then to you, the appellant, you're hearing that they're willing to help you with this issue, but your end, you have to also be responsive and make sure that, you know, if you're out of the country or wherever you are, that you're at least communicating with them so they know that you haven't just dropped off the face of the earth. In which case, then, you know, you're gonna have more issues with them in violation notices and things. So it's a two-way street, and you all just need to communicate with each other. And this is a very unfortunate situation all around. So, you know, we as a board, I think we sympathize with you and with you on it's going to be a difficult issue to resolve, but it sounds like the two parties are willing to work together on it.
Yeah, we'll get it done.
But the only other problem is that I know this is the end of the year, you better start a new fiscal year for the city and repairs in the area. The sidewalks that was put in, according to the city, is saying this is it. We're gonna move on to another area next year. So the money being allotted for the other area, and this street, Quebec, haven't even been touched as far as the problem with the water. So hopefully to get this on the docket to have done for the next year or so, and not 2 years down the pike, because the problem's ongoing.
Yeah, and I think you're hearing from Mr. Lopez here that it's a priority and that they're going to work with you and the other departments that they need to work with to get the overall water issue resolved on this street. In addition, you also have your council person, you know, if you continue to have any problems, you have that avenue that you can take as well to reach out to them to try to get resolution if you need to. But, you know, we as a board hope that this gets solved. And, you know, you're able to not have that sinkhole in your front yard anymore.
And meanwhile, we as the board have to decide
Yes.
what we're going to do with this appeal. So before I call for a vote, are there any other questions from the board? All right, hearing none, I'll entertain a motion.
Madam Chair, given the extensive testimony that we've heard today and the statements by Mr. Lopez and his willingness to coordinate the other city agencies and work with the appellant to reach some sort of middle ground, if you will, and not leave him instead of high and dry, low and wet. I move that we uphold calendar number 25-156.
All right, is there a second?
Board Member Roca, I second.
All right, can we call the vote?
For the record, this is calendar number 25-196.
Yes.
Mr. Madison,
Yes.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Faith,
Yes.
Ms. Wilson.
Yes.
Calendar number 25-196 is denied. The decision of the city has been upheld. This decision will be ratified next Monday, and we will send the appellant a letter.
All right, that concludes this matter. Thank you for coming down. Good luck with this project.
Good luck to you all.
My watch is screaming. You need to. Yeah. All right, we're going to take a brief recess, and we'll come back at 11:57.
All right.
Sorry. All right, we're calling to order so that we can address our final case of the day, which is calendar number 25-123. I know that we do have the appellant online, so we'll go forward with reading in of the case. And if you're present for this case, please come forward. Ms. Holzer?
Our next case is calendar number 25-123. This is at 5011 Clark Avenue. It is a violation notice or administrative appeal of a violation notice. Gill House LLC owner appeals under the authority of section 76-6 of the Charter of the City of Cleveland and section 329.02D of the Cleveland Codified Ordinances from the notice of violation number V250-17517 issued on May 29, 2025 by the Department of Building and Housing for failure to comply with section 327.02B and C of the Cleveland Codified Ordinances, which state that there shall be no change, substitution, or extension in the use of any building or premises until the required use permit and certificate of occupancy has been issued by the Department of Building and Housing. Per section 347.21, any establishment using 20% or more of floor, shelf, and/or display areas individually or in the aggregate for the sale of smoke shop products is defined as a smoke shop and requires an application and approval from the Department of Building and Housing. This case was postponed from August 25th due to the lack of 5 board members being present. It was postponed again on October 6th to allow time for staff to acquire documentation from city inspectors. And with that, I will hand over to Ms. Roca for the oath.
I'm swearing in all who are present for this case. Do you swear or affirm the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply with I do, state your name, spell your name, and give your address. So.
Thank you. My name is Michael A. Glazer, Glazer. Assistant Law Director with the City of Cleveland. I will not be testifying, but I'm here to provide legal argument and inquire of the witnesses.
Inspector Aaron Arnold, AARON, I do.
Address, truth.
Address 601 Lakeside.
Anastasia Smith. I can spell it again.
Yes, so you have to say you do and do.
Every time. Got it.
Give your address.
Sorry, my bad. I do. It's ANASTASSIASMITH. And then 601 Lakeside.
And then on the poll, we'll move over to you. Liam.
Sorry, I had a connection issue. I just got back on. Did you guys say something to me?
Yes, so we're swearing you in. So if you want to raise your hand, state I do, state your name, spell your name, and give your address.
Oh, sure. Okay. I do. Nico Fung Chung. My name is spelled NIKKOFUNGCHUNG, and the address is 15109 Trisket Road, Cleveland, Ohio, 44111.
Great, thank you. Is there anyone else on the call who wishes to speak in this case? Looks like it's all mostly city and board members. So I think we're good. Back to you, Madam Chair.
All right, thank you for that. Can we have?
Madam Chair, would you like, before you take any more, before you take testimony, would you like me to do a summary real quick of the testimony last time?
Sure.
So this was on October 6th. Ms. Nico Fung Chung, business owner, stated that they were told by the owner that all they had to do was acquire their health approvals. They argue that they never operated as a typical smoke shop. They created a third space where people can hang out without alcohol. They serve THC infused drinks items. It's like a cafe. Chief Leonard stated that when the inspector visited the site in April, they witnessed the sales of smoke shop items. Therefore, the city believes that the violation notice was issued appropriately, and that the appellant should apply for a variance. There was some confusion regarding the inspection at the time, and therefore the board, without photos, was unable to really make a decision, and at that time postponed the appeal.
Okay, thank you for that. All right, can we have legal, please?
Madam Chair, members of the board, appellant is appealing a violation notice issued by the Cleveland Department of Building and Housing. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by a preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, thank you for that. We'll give you the floor. Ms. Feng Shang, go ahead and tell us about your appeal.
Okay, thank you. I'm going to stop the video just because my connection is weird and I know we had issues last time. So thank you for that summary. I did want to clarify that yes, we do have the option to infuse coffees and teas, but it's just an option. We do have a number of customers that come in and just have it regular. We curated a very unique menu with different flavor options, and we don't want that to be lost in the fact that there is the option to infuse. We are, as stated, a third space with options to have events, host events. We keep open mics. We have become somewhere that the people in the community definitely rely on as somewhere they can go. There was not much going on in the area prior to us arriving. And also, as stated, the previous owner, which would not be Gill House, it was Ronald Jacobson. He did advise us that these things were taken care of, and in response to the alteration and enlargement without a permit, that would also be under Ronald Jacobson. He did those alterations prior to us signing the lease, so we are not able to speak in regards to that. I did try to reach out to him and see if there was additional information. He was unresponsive. The current owners, Gill House, they inherited this property and all the problems that lie within, I believe, maybe 6 months ago. So I guess our stance is that we maintain our intentions, our business plans and operations do not meet the criteria of a smoke shop. As you guys have laid out, it has to be 20% or more of your shelf, floor, etc. displays in aggregate. We don't meet that criteria at all, and we've never wanted to meet that criteria. When I believe it was Mr. Arnold came into with us, he did advise that we needed to provide a certificate of occupancy. At that time, we reached out to Ronald Jacobson to see if we could get that, and what he provided to us, we were advised was not adequate. At that time, we submitted an application by mail at the beginning of May, which is still in a pending status. And then we had a formal violation posted on our door on June 3rd. In the previous hearing, it was ended, as you stated, with Ms. Leonard, I believe, requesting a continuance, as there were no photographs present to support the violations and there was no inspector to speak in support of said violations. I provided a detailed shelf plan that we use for merchandising that laid out and categorized the items that are on display in our store. We sell novelty items, collectible items. We have food items, clothing, sneakers. And again, we have art supplies, a library, a bookstore. There's a lot more there than an average smoke shop would have. Let me see, hold on one second. I did, after the last hearing, we received 2 visits. One from Kayla Flake on October 8th, and the second was from Drazen Blazovic on October 13th. On October 8th, Kayla Flake came in and she stated she was there for a quote, vibe check. She asked a few questions about our sales and our numbers and our operations, which all were answered. She then, on October 13th, Drazen Blazovic came in and he stated that we were indeed below the 20% that would require us to identify as a smoke shop, and that our business reflected what we stated. He advised he was emailing his inspector to reaffirm that information. I spoke with him on the phone later that day, and he stated to me that I needed to hurry and submit an application for a certificate of occupancy, or we would receive a second violation. He told me we had 30 days to do so. I said, we already submitted an application a long time ago, and I said, it's been stalled. I haven't been able to get any information. Kevin hasn't been able to get any information when he's come into the office as to why that is stalled. He looked up our application. He stated that it was only pending a site plan, to which I responded, we submitted the site plan. It was actually used for our hearing on October 6th, and I was unaware that it wasn't attached to the application as well. He told me that the hearing is completely separate from the application and that I need to complete the application by having that site plan attached. I then sent an email to Brittany Jones, because that's who I'd been communicating with and I had sent the site plan to, asking if she would be able to attach it or if we needed to like bring in a hard copy. I explained what Mr. Blazovic had said to us, and I did not receive a response to that email. So on Thursday, October 15th, my partner, Kevin, he hand delivered the site plan to the zoning office. Kayla Flake accepted the plans, and he again explained the instructions we were given. She was not able to answer any questions regarding why the application was being stalled. Again, we knew there was a hearing, but we were told these two things were separate and that we needed to get this application completed. We were also advised that an email was sent confirming that we don't operate as a smoke shop. So we were just a little confused on what was taking so long. She could not provide a turnaround time or any additional information. She only advised that Ms. Leonard was out of the office until Monday. And as of now, we have not received any updates on that application. Today, we're just asking that these violations be dismissed as they have not yet been substantiated. And we do not operate as a smoke shop. That's been confirmed quite a few times, I think now. And we just want to get our application completed so we can be in compliance, which was what we were trying to do back in May.
All right, thank you for that. I will turn it over now to the city to demonstrate, to testify as to however they wish.
Okay, thank you. I'm aware of the time, so I'll keep it brief, but I do want to hear from Inspector Arnold, or I'd like the board to hear from Inspector Arnold, and ask him how he arrived at his conclusion. He's the inspector that issued the violation notice as V25017517. And I believe that after hearing his testimony, the board will see that his decision was not illegal, arbitrary, capricious, unreasonable, or unsupported by a preponderance of evidence. And with that, I will ask Inspector Arnold, you're the inspector that issued the violation, the V25017517?
Yes.
Okay, and what did you witness that caused you to issue that violation?
We witnessed the smell of marijuana in the establishment, the products that are deemed smoke shop products being sold there, along with the infusion of liquids, which falls under being ingested under the codified ordinance. So that led to the initial violation, operating as a smoke shop without the occupancy.
And you determined that it was greater than 20% of the store was devoted to smoke shop products?
Yes, we later determined that it was over 20% because according to the MLS listing of this property, they have 2 retail bays, which equals 984 square feet. To be excluded from the smoke shop definition, less than 94.4 square feet of the space can be used for the sale of smoke shop products. They do have 2 5-foot by 3-foot display cases, but they also have a back wall that includes the sink cups, the flavored syrups, contribute to the area being used to make and sell smoke shop products, which are the infused drinks. And that's what makes up in my eyes more than the 20% retail floor space and shelf being used for smoke shop items. And then you throw in the fact that Clark Elementary is 2 blocks away, and then that there is another fully established smoke shop within 2 miles at 4210 Clark.
Okay, and if I don't have any further questions, if I might add that Inspector Arnold has stated to the board what was his standard and how he arrived at the conclusion that it was greater than 20%, and we ask that you uphold the violation. Thank you.
All right, do you want to give comment as well?
Are you speaking to me?
No, I'm sorry. I'm speaking to the inspector, Inspector Smith.
All right. So it was mentioned that, that the business, sells teas and beverages of that sort that are not infused. However, it is heavily marketed as such. First, the business being titled the gas station, as well as looking on their website. The intention is to sell the infused, different cafes or different beverages. As we saw on the website, it's marketed as the first ever cannabis cafe. So while sure, maybe everybody doesn't infuse their beverages, it's the intent that the cafe is there to, or the beverages at the cafe are infused. On the website, it shows that there are different levels, I guess, that you can infuse it, which show THCA, HHC, and Delta 9, which are all products that are considered products that can be ingested, which is why we believe it falls under the smoke shop category.
All right, thank you for that. So there was some testimony that this space is a total of 984 square feet. Did I understand that correctly?
Yes.
Okay. And so if the space is 984 square feet, then that means, let's just say, I don't know, maybe 200 of it would be the 20% mark. Why don't you chime in?
So the total retail space is the 984. However, the space itself is set up to supply or hold 2 stores. So the gas station itself, where the cannabis cafe is located, is half of that. So their floor space or area is 492 square feet.
Okay. Okay, so that's helpful. So it's 492 square feet. And so therefore 20% of that 492 would be 98 square feet. Now, you mentioned in your assessment that there were 2 cases which measured 5 by 3. And I think that gives us about 30 square feet. But we need to get to 90 in order for it to be 20%. So can you help me understand?
So if you include the back wall where the drinks are being made,
Okay.
and being infused, if they are purchased as infused, I would consider that also a display area, or not a display area, but an area where the smoke shop items, the CBD, the Delta 8, the THC, are being kept and being manufactured to sell. So I would consider that also, which would put that over 20%.
Is that back wall a 5 by 3 display case as well?
No, the back wall is the back wall of the establishment.
Do we know the measurements of that back wall? Or however much that floor space is?
Not off, I'm looking at the site plan on the MLS listing. And it is not stated on here, but it is longer according to the pictures. If you look at the pictures, you can see that it is a lot longer than the display cases.
Okay. I'll give Nico an opportunity to respond. If you can quantify the size of that back shelf and sort of what the 20% is comprised of, that would be helpful.
Yes, gladly. I would like to respond to a few things. So firstly, in regards to our website, the information listed on our website is there for transparency. It's not there because we are saying that this is what you should or have to do when you come here. Again, it was meant to be a place to replace bars for people who don't drink alcohol for whatever reason, like myself, or people who are just enthusiasts. And just like a cat cafe isn't a pet store, we are not a smoke shop just because we are cannabis themed. Yes, our decor, yes, that is the idea of it. And the gas station name has very little to do with, cannabis. It is because gas stations are what would you call it? It's just a thing in Cleveland, right? People go to gas stations for food. They go to gas stations to buy other things. It's just a known thing. And we were staying within that theme of Cleveland and the importance of gas stations in Cleveland and using that as a name for our social space. In regards to what we signed on our lease, yes, it was previously listed as two separate storefronts. However, upon entry, and if you walk through the store, you'll see that that probably was not a very viable setup, as the two doors when you walk in are pretty much facing each other. So if you had customers from store A going out and store B coming in, they would constantly run into each other. When we signed our lease, it included the entire space and they work in conjunction with each other. Our bookstore and our library are on the other side and they're included. We also have clothing racks on the walls. We have a sneaker shelf. We have a refrigerator with completely uninfused beverages. We have video games. We have, like I said, collectible novelty items, all in that same area. In regards to the back wall, the cups there, the flavored syrups, which are not infused, are all used in the tea making process. We have a long menu, two menus actually, with artisanal teas, recipes that we came up with that we make. People come in there for all sorts of reasons, not only for infusion. And the items that are infused, the items to infuse are in the case, which was already accounted for in our shelf plan. And it's only that one front case. The side case holds t-shirts, board games. There is a cannabis themed board game in there, but that is not a smoke shop item. It is a novelty item. We have a jewelry display. There's just so much more there. And I don't think it would be fair to kind of pigeonhole us when we're stating what our business is and trying to give you an understanding of what we do there. It's really hard to do unless you come and actually like experience it, but it is not what it's being made out to be. And I do think that we should look at the entire picture and not just the fact that we do offer the option to infuse. It is just a place where like-minded people can get together. We have chess competitions. Like I said, we have open mic, we have karaoke. It is just a place to be.
Okay, so it's your testimony that you are operating both of the storefronts and not just one?
It's both spaces belong to us. We leased both of them. So yes. And that was something that when we went and did the certificate, we had asked about that because we wanted to know, because they're insured separately, just because of how it came about with the insurance people. But we wanted to make sure that we took care of this issue first that was on the violation and then figured out what you guys needed in regards to everything else. But to answer what's being discussed today, we do not operate as a smoke shop and we don't meet that 20% criteria, even with the back wall. And I believe there are measurements, my computer's moving a bit slow, but the back wall measures 24 feet, 8 inches in totality. That's from the front of the store, like the window, all the way to the back door. And if I had to just quickly, without having like measuring tape with me, I would say of that 24 feet, maybe 3 feet of that falls behind the counter. And that's me looking at the length of the shelf, the display cabinet. So again, I don't think that we meet that criteria. And that's what is being asked today.
All right, thank you for that. Chief Leonard, you want to chime in here? I saw your hand up. Maybe that was not because you had something.
Sorry, I was on mute. Shannon Leonard, Chief Zoning Administrator. She just answered a couple of the questions that I had, and I just kind of want to talk about the occupancy permit that was submitted. There was a lot of questions because there was conflicting testimony from the neighborhood as well as the applicant as well as the City of Cleveland inspectors as to what was happening at this space. And we really wanted, and we continue to talk, I believe, to her partner about making sure that you got the right occupancy permit for exactly what you're doing. And there was a lot of back and forth in terms of what was happening. And so the things that she stated here today are different than what her partner had stated. Originally, they submitted as a smoke shop, then they submitted as just a cafe, and said that they weren't selling any smoke shop products. And then they also weren't having any type of entertainment or events or anything like that, which contradicts what has been testified here today. So I just want to clarify a few things. Do you sell THC infused products? Whether that's drinks, gummies, candies, things of that nature?
That's for me?
Yes, through the
Okay,
chair.
thank you. MS Leonard, I did, just because I forget things, I want to make sure I address that as well. We've never submitted an application, any applications as a smoke shop at any point in time. We were told when we first tried to bring in our application that we had to, and then we tried to figure out why that was and what steps you guys wanted us to take. But again, I've always stood on the side that we were kind of being railroaded because our concept was misunderstood. And I've sent emails personally and tried to call the office to provide the clarification that you're saying you're needing. Again, we did state earlier, and it does show on our website, we do offer the option to infuse. We do sell some items that would fall in the smoke shop category. However, it does not meet the 20% criteria for us to have to apply as such. And we don't want to meet that criteria because we don't want to be a smoke shop.
Okay. Do you allow smoking on site in either of the storefronts?
We have a backyard area where people can smoke. You can consume your tea there on the cafe side, which is not much different than another cafe that also operates in Ohio, which opened after us. So yeah, that would be the answer for that. They can consume those items there. If you want to step outside, you have the option to smoke there. That's perfectly fine. But outside of that, we keep everything the way it should be. When we're closed and we're not open to the public, then it's our space to use as we feel to use. And so we do that. And in regards to the school being down the street, when we got there in 2022, that school wasn't there. But since we're not a smoke shop, I don't think that'll be an issue, but that was just something else I thought I should point out because I see it on the screen. That school was not there when we got there.
Do you, through the chair, do you allow vaping or hookah use inside?
No. No, sorry, I didn't know it was for me.
And then do you have karaoke or other events such as the things that you listed previously?
I wouldn't call it an event because we don't it's not like something people come to like in droves. We do have the option to sing karaoke if you'd like to. We have a microphone, we have a speaker, we have several, two TVs on that side. And so they can do that. They can also paint. And occasionally we do have like a special event. We'll do like a lighter design party or something of that nature. But those are private and it's when we're close to the public.
Okay. Thank you. That allows us to help us to clarify what your occupancy permit will be for. Thank you.
All right, so what the board is here to decide as of right now is whether when this violation was issued back in May 29th, there was greater than 20% floor shelf that contained smoke shop products. So we've gone through the measurements, we've gone through pictures. I'm not seeing that the 20% threshold is exceeded. Am I
Madam Chair,
missing something?
So the definition is 20% or more of floor shelf and or display areas, and that's individually or in the aggregate. And I believe the inspector clarified that square footage.
And he did, but it didn't come up to 20%, which is why I'm wondering if I'm missing something. So he clarified square footage. If we look at one side, it totaled about 30 square feet. And then we talked about the back wall, which she stated about 3 feet of the back wall should be considered. That puts us at 33, which I'm still, I guess I'm not understanding the 20% and whether we're there.
And, Madam Chair, are you including the infused products, infused teas and drinks? Because I understand the argument that they may or may not be infused, but if they can be infused, I think that would be a smoke shop product.
So she stated that the items that are on the back wall are simply items for tea. And then if someone elects to have the infusion, those are in a different case, which the cases have already been accounted for. So that's why I'm just like, am I missing something?
I don't believe that that's the case. I believe that there is more than 3 feet of the back wall being used for Delta 8 or Delta 8 THC for smoke, anything smoke shop related. Would constitute that more than half of the back wall is used for that. And then just because they may have a setup and a sink for tea and stuff, then the area that they are infusing it at should be qualified as one too, correct?
That would be a question for the attorney. Is that included?
Well, I think that is the argument that I'm making, that if it's that you know, as the ordinance says, floor, shelf, or display areas individually in the aggregate used for the sale of smoke shop products, and an infused tea would be a smoke shop product. So whatever area they're using to sell those products would count towards the 20%. And I think that's much larger than a display case.
Okay.
Can I say something? I'm sorry.
Go ahead, Nico.
Okay, so I do understand exactly what you're saying. And so what I'm stating is in this picture here, as you can see, everything in the back is just cups, a sink. We have our cleaning products. We have gloves. To the right, you have Torani flavored syrups. And then
Hold on a second. Which picture is the back wall in question? Is it the top right?
Yes, the top right shows you that 3 feet of back wall where there's stuff there, teacups, coffee cups, everything right there, spoons, so on and so forth. This first counter in the front is what is accounted for with everything inside with the smoke shop products. Actually, when we make tea, we turn around and we put the cup right there on that counter. So that's the only area where that would be used. And again, like I said, people come in all the time for just regular coffee. The gas station across the street was not operational for quite some time, as some of you may already know. When we got there, it was not operating as a legitimate gas station. People in the neighborhood were coming to us for regular things you would get in a gas station, like potato chips, drinks, coffee, and tea. We offered that here. The option to infuse is there, but it's within that cabinet, already accounted for in the 20%. And I don't think it's fair to state that just because we have cups that can be used for, either infused or non-infused, that, that makes it any more of the 20%. But even if you want to include that wall, it still doesn't meet the criteria. To the left, which isn't pictured here, it is kind of at the bottom right, to the left, below those posters and above the posters, we have retail items. Below that, we have sneakers. To the right, there's a jewelry counter. To the left, there's ramen and other snacks you can buy. So I just don't see how we're getting to that number based on this picture here. The wall literally goes all the way down the back to the back door. That's 24 feet. And only that small section of that wall is for tea. So even if we include that, it doesn't meet the 20%.
Still not at 20%.
Through the chair to the appellant, I have a question based on the testimony that you just provided. So if it might help if you could tell us how the infusion works, because I am zooming in on the picture of your back wall and I see the Torani syrups, I see the cups, I see things that would be normally made for regular tea or coffee. I see we can see that there's a sign that says you can get tea, coffee, and hot chocolate. So and you're saying the infusion happens on the case. So the applicable products are inside the case. How do you infuse it and where does that happen?
Correct. So right there on the counter, let me see, how can I say this? I know this is public. We don't want to give away all our recipes and secrets, but it's just a syrup. It's a compliant syrup that we order from a compliant company that uses hemp-based products. We have on site all of the documentation for those products, the COA reports and everything to make sure that we remain in compliance. And that information is done right there. So when someone orders a tea, we get the hot water, we go over to our loose leaf teas, we put that in the hot water, then we have flavoring syrups, and then the last step would be infusion with that syrup. And that's done on that same counter, and it's stored in that counter.
So
The one that's
the cannabis or whatever, the hemp products, whatever, the products in question, the syrup in question that is can get you high. That is in the case. It's not, I see there are many syrups behind the counter. So are the syrups behind the counter the infused syrups? Or are they just non-infused syrups?
No, those are just Torani flavored syrups. We have a lot of them because if you look at our menu, I believe we have in total about 26 different drinks and flavor combinations that you can order. So we have the flavors to complete those orders. That's all that's there.
Okay, so the syrup, the intoxicating syrup is inside the case then?
That's correct.
Madam Chair.
Please.
This is Shannon Leonard, Chief Zoning Administrator, and just in case of to clarify, it's not exactly where in the store that they are infusing the products. It's the 20% or more floor, shelf, and or display areas individually or in the aggregate that is used for the sale of smoke shop products. So it's not just the shelf, it's not just the display area, it's where are they being used in the store. And so when the inspector went out, they found that it was greater than 20% here. This is a violation notice. They could come back for their occupancy permit. And then I just want to clarify, a couple weeks ago, we had this same kind of argument from a veteran who had a similar cafe congregating space with the sale of smoke shop products as well.
But Ms. Leonard, what we're trying to clarify, we have a difference of fact here. The city is saying that you're saying anywhere that the products can be infused counts. And what the appellant is saying is that the products are only in the case and we've already counted the case once. So why would we count it twice?
So it's not where the products, it's any retail establishment in which 20% or more of the floor, shelf, and or display areas individually or in the aggregate is used for the sale of smoke shop products. So if more than 20% of their floor space is being used for the sale of smoke shop products, they would be considered a smoke shop at the time of inspection.
And I think what we're grappling with is we're not seeing how it exceeds 20%.
I will defer back to the Inspector Arnold and the attorney for the city.
Okay.
So, yes, we counted the cases already. We're adding, or where we see that it's greater than the 20%, what we're counting is the additional, is that additional back wall. You can kind of see it up there. So while the appellant mentioned, well, not everybody doesn't infuse their beverages. The sink is still being used, whether it's infused beverages or not infused beverages. The flavored syrups, whether it's infused or not, they're still being used for the infused beverages. The cups, the way the teas are made, whether it's infused or not, it's still being used to create or to make the smoke shop products. It might be a stretch, I don't know, maybe, but so the appellant had mentioned that the wall, like stretching from the sidewalk back, like that way.
The back wall.
Yeah, was 24 feet.
And 48 inches.
And only 3 feet of that is being used for this tea session. So even if we count the part that's being used for the tea concession, we're still not at
It's
98.
bigger than 3 feet. That's what I'm trying to.
Okay, that's probably what I'm missing.
That's what we're trying to show. So I wish they could
Okay.
put it side by side.
Hold on a second. Hold on. The inspector has the floor. Go right ahead.
So where's that other paper at? Here. So this is the site plan. This is I don't know if they can pull it up.
We had it
there.
from the last hearing. She showed us a,
Okay, so from here.
I think we might have the same one. Is that, oh,
No, that's different. This is a site plan on the
Oh, not the
actual
floor
listing of
plan.
the property and not a hand drawn.
Okay.
floor plan too, that was submitted as well.
So this is the 24-inch
That's the 24,
wall.
yeah.
But this entire wall is not being used for,
Correct. It's what from visual, we would say it's half. So 12 feet, maybe not 3, but 12.
that still doesn't get us to 20%. We have to get to 98. We're at 30. If we add 12, that puts us at what, 40?
So if you
Let's say
take the
50.
height of the wall to give you the area,
Okay.
the height of, and that's listed on the county site, the wall height is 10.
So you're saying the space that's being used on that back wall is 24 by 10?
12, I would say 12 because it's not the whole thing all the way back. I would say it's half of that. So it would be 12 by 10.
12 by 10. Okay. All right, so the city's position is that half of the back wall, which is, let's say 120 square feet, is being used for smoke shop items in addition to the 2 5x3 cases.
And it does not have to be the item itself, but used for the sale of smoke shop products. So we can see in the pictures, the sale of the teas, how high and, that's used for the sale of a smoke shop product. So that would count towards the total. So floor, shelf, display, in aggregate, adding them together, those would be smoke shop products used for the sale of smoke shop products.
So because the sign is there, that would be counted.
Well, that's what the ordinance talks about is that space used for the sale of smoke shop products, which that undeniably, a poster selling a smoke shop product undeniably is doing.
Okay, go ahead.
I was gonna say, along with the other walls that are in the lounge area, where smoking goes on at. All of that we consider too as either displays or form of advertisements of displaying of smoke shop items. So all of that put together is how we came up with not just a strict, this shelf is holding blunt wraps and this shelf is holding cigars. So we don't consider a cigar, we took into account everything throughout the 2 retail spaces that are being used to advertise, sell, or infuse.
Okay.
And then with the smoking going on in there, that we consider that a smoke shop.
Okay, so that kind of tells more of the story than I think what I registered before.
Mhm.
Are there any other questions from other board members?
Madam Chair, I have a question just to clarify. It sounds like she has seating, sort of a cafe or lounge set up where people can enjoy their tea, infused or not. But I'm wondering if the consumption of infused tea also counts in that lounge area as part of the aggregate square footage.
I think that's what we're
Which-
hearing from the
yes.
inspector.
Yeah, we would consider that part of.
Okay,
In
any
which
other
ca-
question?
In which case that square footage would have to be added. And the other question I had is looking at a historical photo from August of 2024. There is a window sign that says how high, and then there is a correlation to gasoline octanes, with octane 87 being delta 8, octane 89 being delta 9, octane 93 being HHC, and diesel being THC -0. I see in current photos that has been removed, but clearly that indicates that there was sale of smoke shop items at least as late as August of 24.
Can I
All right.
respond?
Thank you for that, Ms. Faith. Hold on a second. Are there any other questions from board members? All right, Nico, you have the floor briefly.
Okay, thank you. So for the first part, I wanted to respond to the wall and saying that half of it was being used. Again, in the images, if you just take a look, the counter, the 5-foot counter, there is the one in the front is the only one that contains any of those smoke shop items. Behind that wall, you have this, behind that counter, there's the space for the sink. I understand that they're saying that the one poster to the left makes it an issue. If we move that poster over to the right, it would just become a part of that other space. We can switch it with the karaoke poster. That is not a major issue at all. The second cabinet, like I said, holds games, t-shirts, and everything, and should not be included in the math that's being done. I'm not sure that I completely agree with the statements on how the lounge side is being used. Again, it's used for a number of different things, and it's also operated and used privately when we are closed. So I don't know. I get why they're wanting to include it for their own purposes. I don't 100% agree with that. So I don't have like a rebuttal for it because it just doesn't make sense to me. Again, there's another.
Let me ask you this, Nico. When someone comes in and purchases infused tea or even any other smoke shop product, are they permitted to go anywhere in the store space, in the lounge, or anywhere in the space to consume those products?
So we have a gold card membership that allows you to utilize the lounge space. Again, like I said, it's operated as like a private situation.
Hold on, Nico, just directly answer that question for me. Yes or no? If someone purchases infused products from your establishment, are they permitted to use those products either in the store section or the lounge section?
Yes, if they are a member, they can. Most people leave the store. They don't stay in the store section.
Okay, got it. Thank you. Did you have additional comments?
I did. So at the wall space that they're saying, if they want to include it, 12 feet is not accurate. I'm more than happy to move the poster over if that's the issue, but I don't feel that that's fair or accurate. And then in response to the question about the signs in the window, so as I had said, when we first opened, there wasn't much going on that street. We needed to cover the windows for our own safety. We've had a number of, in the beginning, safety issues at that location where we'd have to reach out to the police and even to the mayor to get some of those things addressed. We had the coverings so that people outside weren't sitting outside and staring at us all day. So it was just repeats of our posters, and we just got them printed to put in the window. Those were taken down because Inspector Arnold let us know that we couldn't have them. So we just took them down. That's why they were removed. But I don't think it speaks to the fact that we sell smoke shop products, because we do. We just never sold more than, like, we don't agree that we meet the criteria of 20%. I think that's just really where we stand. I know that it's going to be a matter of opinion on that, but I definitely think based on the measurements and the space and what we do, that we don't meet that criteria as a smoke shop. And if there is something like a poster or a sign that we need to remove to change that, then we would happily do so. But in regards to operations, I don't think that we meet that criteria.
Okay, so the board is going to make a decision about, on the date of inspection, whether that 20% criteria was met. And you can work with the city going forward to determine whether you need to, apply for a smoke shop permit or whether you meet that 20% criteria going forward. But what we're going to address today is what happened on that date of inspection. So I'll give one final call to board members for questions. If there are no questions, I'll entertain a motion.
Madam Chair, I think we also need to reiterate the saturation and the distance issue.
Yes, thank you, Ms. Faith. Mr. Bay, can you chime in there?
Yeah, so this is Xavier with City Planning. This is actually a violation notice that we're hearing, not a use permit variance. So at this time, the main decision, I believe, is to be made on if they were in operation without a permit, and not actually the whole adjudication of the permit. Thank you.
Thank you, Mr. Bay. I would agree with that. Are there any other questions from the board?
I'm ready with a motion, Madam Chair.
All right, please go right ahead with your motion.
Okay, regarding calendar number 25-123, I move that the violation notice be upheld.
All right, there is a motion to uphold the notice. Is there a second?
Board Member Roca, I second.
All right, Ms. Roca seconds. Can we call the vote?
Mr. Madison,
Yes.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Wilson.
Yes.
Calendar number 25-123 is denied. The decision of the city has been upheld. This decision will be ratified next Monday, and we will send the appellant a letter.
Okay, thank you so much.
Madam
All right.
Secretary? Madam
I'm
Secretary,
sorry, Ms. Faith, did you say something?
my vote would also be in, was not called and would
Oh,
be,
I apologize. Thank you. Thank you. Ms. Faith?
yes.
Thank you. Sorry, now it passes by
that.
unanimous vote.
Okay.
Denied. Thank you.
All right, so that concludes this matter. Nico, you can work with the city going forward about what arrangements you can make to come within that 20% threshold if that is your desire. So we'll close this out. That is our final case of the day.
Madam Chair, there was a case that was overlooked at the beginning. This case has been moved a couple of times. So I didn't see it. Actually, I have a version that didn't have it on there. It's calendar number 25-152 at 4239 West 143rd Street. Samuel Rivera was requesting to construct a 960 square foot garage. This has been moved a couple times because we're working on updating the adjudication, and it at one point was scheduled for November 10th. It has been moved to November 17th. Just wanted to make that announcement.
Okay, and has there been adequate time for us to like post notices?
Oh,
and
yes,
stuff? That seems
absolutely. Yes.
fast. Okay. All right, perfect. So we will not hear testimony on calendar number 25-152, and that will conclude our matters for today. I'll look at old business. There are a few items up for ratification, specifically number 1 and number 6 through 11. Without objection, board?
Without
Without
objection.
Objection.
All right, all of those matters will be ratified. And then we do have one miscellaneous case. It looks like Fran DiDonato and neighbors have submitted an appeal to the Court of Common Pleas of calendar number 25-137. So just an informational piece there. We will follow that appeal and see what happens. It's now 12:49. We are adjourned. Have a great day, everyone.
Thanks.
Have a good day.
You too.
What time did we actually start?
Not here next week, so I will hopefully be.
Take me with you.
What was?
Liz,
Yeah, what was that, Ms. Faith?
what time did we actually start?
I know.
I'm sorry, I can't hear her.
What time did we actually start?
I think we started at like 9:05.
9:35.
I'm sorry, 9:30.
Yeah.
All right.
You didn't miss even did she miss one case?
No, she came through on the preamble when we were about to talk
Okay,
about
good.
post